Justice Suryakant, I just want to, Your Lordship asked me that question on Section 22 of the UGC Act. Kindly have a look at the UGC Act. Volume 4A, PDF page 214.
Volume 4A. Page number, Mr. Sidhu?
Page 214, Madam. Volume 4A. Now, we just read it, Madam. The right of conferring or granting degrees shall be exercised only by a university, established or incorporated by or under a central law, a provincial law, or a state act, or an institution deemed to be a university under Section 3, or an institution specially empowered by an act of parliament to confer or grant degrees. So, as a matter of law, I can't get a degree. I can't be called a university unless I'm incorporated under the Central Act. Now, where does this provision come from?
Mr. Sybil,
Yes.
please refer to Section 23.
Yes,
In
that
this
was
case, the proviso will apply.
Yes.
And 22 may not apply.
No institution, whether a corporate body or not, other than a university established or incorporated by or under the Central Act or a provincial or a state act shall be entitled to have the word university associated with it, provided that nothing in this section shall, for a period of 2 years from the commencement of this act, apply to an institution which immediately before such commencement had the word university associated with its name.
So what happens is, in this case, because it was already a university.
Correct.
By a Central Act, is the proviso which will come into play.
Correct.
And for a period of 2 years, there was hiatus.
Correct.
They could then apply and confirm, or the UGC
Correct.
will confirm their status as a university.
Correct.
And accordingly it will proceed. In this case, because it's more than that, because they were already included in the 7th
Right.
schedule entry 63.
Yeah. But I'm not in that
22,
context.
22 and 23 occupy different fields.
Yes.
22 deals with the right to confer a degree.
Yes.
23 deals with the use of the expression university as part of your name.
Absolutely. I pointed out 23, my Lord pointed out 22. But Malas, I have a different argument to make. What my Lord is saying is absolutely right. But my argument is, where does 22, 23 come from?
Just read 22(1) again. Once
Very
again.
well. The right of conferring or granting degrees shall be exercised only by a university established by or incorporated by or under a central act, a provincial act, a state act, or an institution deemed to be a university under Section 3 of the of an institution specially empowered by an act of parliament to confer or grant degrees. The question that your Lordship should ask yourself is, where does this come from? Where is this provision? What's the origin of this provision? And the answer is 1906. Now let's go to 1906. Just go to 1906. That's to answer my Lord's question. Nothing in clause, I'm sorry. Do that. And there's 2 parts. those statutes.
Twenty-three refers to an institution which is not established or incorporated by or under a central act, provincial act, or state act. The substantive part of 23 says you cannot use the expression university as part of your appendix.
Correct.
The proviso, however, contemplated that there may have been universities earlier
Yes.
which were using the expression university,
Yes.
though they were not covered, they were not.
So you are given 2 years.
You are given, it's a sunset clause.
Absolutely.
You're given 2 years to bring yourself in conformity with the UGC Act.
Absolutely.
This case, AMU is not within the proviso for this reason. AMU had already been constituted under an act of the then Dominion legislature, and which law continued in force after the Constitution under Article 372 of the Constitution.
Exactly.
Those laws all continued post-independence.
Yes.
So it continued to be a statutory university. As a university governed by 23, it had the right to award degrees.
Yes.
That's how they acquire the right.
Right.
But your argument is without this, they wouldn't have had the opportunity to award degrees. Then you would have had to go back to Allahabad University or some other university as it was before the 1920s.
Absolutely. I'm deeply obliged to your lordships. But Manoj, the point really is, and this is a different point, and this really tells your lordship the interrelationship between 1906 and 30. Where does this come from, regulation come from? It comes from 1906. It comes from 1906 because education is an occupation. You cannot, in an occupation, do what you like.
That regulation may also be traceable to 30. For instance, in the context of Article 301 of the Constitution, which is in part 13.
But that's on trade.
That's on trade. But our court said that regulatory measures which facilitate trade are permissible under 301.
But this point was dealt with in TMAPI. The TMAPI said, no, it is occupation. It's not charity. It's occupation. But the surplus that you make when you run an institution must be plowed back into the institution.
Actually, it may not arise here. But all that we are saying is that the power to make regulations, though expressly referable to 1906, is also implicit in 30 because 30, our court has said, 30, though absolute, cannot preclude the parliament or the state legislature, as the case may be, from making regulations which facilitate the character of the
That's
institution.
under 1906, Manoj.
As an institution of excellence.
But Manoj, that's under 1906. TMAPI says that also. That regulation is under 1906. That's why, Manoj, the absolute right is there, but the absolute right has to be regulated by standards.
Yes.
The absolute right is of the choice. Means I can set up a school. The school will be regulated by the education.
That point you made yesterday, that you can set up a primary school, a secondary school, a high school, an intermediate college,
whatever.
a degree college, or
That's the choice. That's the choice. Now,
because a university is also an educational institution within the meaning of Article 30.
Yes. So therefore, but that choice can't be so absolute that you can do what you like. So you have to be you have to standardize your education in terms of the general standards set for all other educational institutions by the majority community or any other community.
And your argument really is this, which we'll hear the other side on, that if you apply the expression administer in a very strict sense, namely that there should be no outsider at all, or exclude you on the ground that, look, there are only 37 out of 180. A minority can never run a university.
No, Manoj, in fact, it is contrary to judgments laid down by this court. Because this court has said that you can have whatever secular education, it need not be only, but St. Stephen's had only 6% minority students at one point in time. Only 6%. Increased to 14% at some point in time. And then this court said in St. Stephen's, in TMAPI, it can go up to 50%. It need not have said so. That's why our Kerala Education Bill is sprinkling of minorities.
Also, one very important circumstance, you can't read Article 13.
Outsiders.
Outsiders.
That's
not
correct.
minorities.
No, no, sprinkling of outsiders.
Outsiders.
Yeah, so therefore you could have outsiders, you will not destroy your minority status.
The object
That's
of
the
Article
point.
30, object of Article 30 is not to, if I may use the expression and don't take it otherwise, is not to ghettoize the minorities.
Yes.
So that, you get other people also associated in the administration, it doesn't detract from your character as
That's
a
the
minority.
point. That's the point I was trying to make yesterday. Now, Malaz, in this university, just to get the facts right, this is, Malaz, there are several departments that are run. For example, All India Council for Technical Education. We have to go to them for recognition.
For medical college, you go to the
For medical college, you go there. For the dental
Architects,
council, we
you go
go
to,
there.
the
For pharmacy,
architect.
we go there. For National Council for Teacher Education, we go there.
The law college will be governed by the bar council.
Correct, bar council. And there are different elements of administration in that. In a medical council, how will we administer at the university? We will not have any expertise. So we'll get outsiders to do it. Kindly see, Malaz, the impact of administration is again my choice. I hope, Malaz, I'm making myself clear. In some of these technical things, we'll have no knowledge, especially in a medical college. So we'll get people from outside and say, you please help us in doing this. And they may be in majority. But the choice is that I will say, please come. That doesn't destroy the character of my institution. So different standards will apply to different disciplines depending on the nature of the course that I am teaching. It is true of engineering as well.
The only difference here, we'll consider it. I mean, I'm not putting it as something against you, but a factor to be considered is that by the statute itself, you have to induct into your court a large number of people who are not minorities. This is as a matter of statutory interdict.
That's all right. But I can challenge it. Let's put it this way.
Does that alter the...
No. I can challenge it, Malaz. Kindly, that's the point that I made yesterday. If the statute interferes to the extent that I feel that my right to administration, which is the right conferred under 30, is being impeded, I can challenge it. But I can accept it. So the statute, and Malaz, we are not here dealing with administration. This, Malaz, please appreciate, Basha never dealt with administration. Basha said, I have come to the conclusion that you are not established. The minority has not established this institute, and therefore you can't administer.
Basha went on the establishment.
So you don't have to go into that, Malaz. We really don't have to deal. The problem arose that in Basha was, the council argued that assume that I am not established as a minority institution, because the administration is
use established and administered disjunctively.
That was the
argument.
That was rejected in Basha. That was rejected in Basha.
There can't be any doubt that it's established and
administered.
You can't read that and as or.
So therefore, Malaz,
you have not. Dr. Dhawan
yes,
has also not argued
and
that.
therefore overwhelming participation of others in the administration, even if they are in a majority, even if by statute, will not destroy the character of the university. Because if I feel that my right is being impeded, I can challenge it. But I'm not. And the fact of the matter is, Malaz, if your lordship looks at the structure, and you need not in this case, because we are not dealing with that. In fact, it was overwhelmingly Muslim despite the statute. De facto. But we don't have to go into that, Malaz. We can't in a reference go beyond what your lordships are asked to decide. So, Malaz, therefore, now I was trying to show, Malaz, that all these regulations fall under 1906. The genesis and the conceptual constitutional genesis is you can't have institutions in the country without standardization in the field of education. And that standardization can only be provided by law under 19. And the law will apply to majority institutions and to minority institutions. And UGC and all other statutes are consistent with 19. The right under 30 is absolute, the choice, but the regulation is to be done under a law by Parliament under 1906. That's more of the submission and the interplay of 1906 with Article 31 of the Constitution. Now, Which page is? The context of what my lord has put in, my lord the Chief Justice. Kindly note, Mullahs, I won't read it. Kindly note, Mullahs, volume 5A, PDF 417, paragraph 41 of St. Stephen's. Volume 5A, PDF 417, paragraph 41 of St. Stephen's. And I'll read that sentence to you. The right to administer is the right to conduct and manage the affairs of the institution. This right is exercised by a body of persons in whom the founders have faith and confidence. That doesn't limit it to the minority. This is 5A, PDF 417, paragraph 41. This sentence is between placetum G and placetum H.
Page number?
417, volume 5A. It's between G and H, which says exactly what I'm trying to, let's say, consistent with my submission before your lordships.
Actually, therefore, it's important to clear a cobweb, which is that Article 30 does not mandate that administration must be only by the minority itself.
That's
In
correct.
the sense that the personnel who administer are not required by Article 30 to belong to the minority
Exactly,
itself.
exactly.
What Article 30 contemplates and recognizes is the right, namely the right of choice, the discretion which is given to the minority to administer
That's correct.
in a manner which they deem appropriate.
Correct.
Therefore, it's not that if you don't have only people of your community,
Correct.
then you risk losing your minority character.
Correct.
Because the choice is yours. You may have persons belonging to your community, you may not have persons belonging to your community.
Just to give an example, Mullah, that I have myself experienced, I happened to be in the governing body of St. Stephen's at one point in time, Mullah. Most of it were non-minority people.
The essential element of Article 30 is the conferment of choice on the minority.
That's correct. That's correct. So we are missing the link, Mullah.
It can't be read in the reverse
Yeah.
to impose an embargo that you will not have anybody save your community.
Mullah, the minority will not have the expertise to run the institution, many of these institutions. Will not have. For force, we'll have to take people from outside. That's why St. Stephen says, have faith and founders in whom the founders have faith and confidence. I have confidence in 10 people in the majority community to run my institution. I'll give it to them to run it. Doesn't make the institution a non-minority institution because it is founded by the minority. The inspiration to set up an institution is that of the minority. The steps taken to set up the institution is of the minority. The persuasion done by the institution to the government and the authorities is by the minority. So as long as these elements are satisfied, it's founded by the minority.
Can you come again on that? The inspiration to set up
The inspiration to set up the institution is by the minority. The steps taken for persuasion are by the minority. The essential paraphernalia of initial funding by the minority. Persuading the authorities to accept that fact by the minority. And all these elements are satisfied in this case. So the genesis of the institution is the test. That is antecedent to recognition. All that is antecedent to recognition. And Basha says because you are incorporated, you have lost the status of a minority. This is the problem. This is the problem with Bhasha. And remember, Malats, when Bhasha was decided in 68, in-ray education bill was already there. Not referred to in Bhasha.
It is referred to.
Well, not dealt with. Siddhaj Bhai. Dealt with also. Siddhaj Bhai already there. And of course, now we have TMA Pi and other issues, other judgments. So the interplay of 1906 is fundamental. Now, Malats, now, as Council for Architecture, we have people giving degrees in architecture. We don't have Muslim community people in architecture. Enough. Anyway, so I'm done with this part.
Now, what remains, Dr. Mr. Sibal, what remains?
I've already said that it glossed over, yes.
What remains now, Mr.
Now, a couple of, how the reference came is very important, Malas. I just give your lordships that. Now, Malas, as your lordship knows, give me that note. And I'm just giving you.
Mr. Sibal, you're quite proficient from where you began last year on your laptop.
No, I'm very
on your
proficient,
iPad,
Malas. Now I'm completely, just that it'll be quicker if she does it than I, Malas, do it. Take it. No, I do it.
But Dr. Dhawan, you have not made any progression at all on that. Just, I must also tell you that there's a world of literature which opens up when you use your iPad.
Absolutely.
Which is so,
absolutely. Yeah. Not
forget
just,
forget all this.
There's also a world of abuse that opens up.
Of course.
We have to suffer, get enriched by one and suffer the other.
Myself from agreeing with Mr. Sibal.
Now, let's just see. Just these note these days. 1899, the MAO College was formed. 1899. MAO College, Old Boys Association was formed. Who is the petitioner here, Maharaj? 1899.
Old Boys Association.
Old Boys Association was formed. And who is the petitioner? I mean, I'm the petitioner here. In 1920, the Aligarh AMU Act was passed. And in fact, that's just a matter of interest, the ordinary members of the court were to be appointed by the Old Boys Association from its own members. That was as per the statute.
The ordinary members of the court
were to be appointed by the Old Boys Association as per the statute. That was the extent to which the Old Boys Association was associated. Then your lordship knows, and I will not trouble your lordship because just Dr. Dhawan has dealt with it. The 51 Act came, which amended Miller's.
Yes,
the Act was amended by the 51.
Means prior to 2020.
In the 2020 Act.
In fact, in the type version, it's missed out.
So they missed out in the type version, it is there. In the
what is the next
version.
date? Were you saying, Mr. Sibal, what is the next
4.
date? I missed that.
Yeah.
What is the next date?
Then 1965, it was further amended, your lordship.
The first amendment was in
1951. Well, it's really the essential element was that Section 9, which earlier said instructions in Muslim religion would be compulsory to Muslim students, that was omitted. That's all that happened. So Bhasha.
In 1951?
Yes, in 1951.
What happens? Just tell
us.
Well,
the instructions in Muslim religion would be compulsory to Muslim students. That was omitted. So Bhasha says nothing much happened. No real amendment. It became optional. It became optional. So it had no impact on the decision in Bhasha. And then the proviso to 23 was also omitted, that only a Muslim can be a member of the court. That also was omitted. Just these two things happened. So therefore, but factually only Muslims continued, but there was a 23. That's what happened under the 51 Act. Now, my lords, in the 65 Act, which also has been dealt with, but I just tell your lordships in a second as to what happened. All powers of the court were given to the Executive Council.
Mr. Sibal, we have the reasons why the 51 amendment was moved, reasons, objects and purpose of that?
I've not investigated it. I'll find out.
Can you just tell us the 51 amendment page, or Junior can just tell you which is?
Yes, my lords, page 99 is the first, paragraph 2B, page 99.
Of volume?
My lords, can I just upload it? This will be given a chart, it's better.
Sure, but 1951.
Volume 4A, I just give it,
4A.
volume 4A at page 99 is the
1951.
Oh, your lordship wants the 51 Act or the 65 Act?
51.
51 Act, the first amendment is section 9 amendment is volume 4A at 90, paragraph 2. At page 90, paragraph 2,
Yes.
which omitted section 9. The second amendment of proviso to section 23 is 4A again, page 93, paragraph 17. 4A again, page 93, paragraph 17. So those are the two amendments in the 51 Act. The religious instruction was made optional for Muslims, and can I just airdrop it, Mullah? It's just a note. You just do it now so that it's easier. We've done it, Mullah.
51, it shows.
Because it's. Yeah. I know that. On the screen.
What?
That's right. Now, Mullah, I just point out. So this was on the 51 Act. Then the 65 Act, Mullah, what did it do? In volume 4A, page 99, para 2B, the powers of the court were given to the Executive Council. This is volume 4A.
This is also volume 4A?
4A. All is in 4A. Page
Powers of?
99.
Powers of?
Powers of the court, erstwhile powers of the court were given to the Executive Council. That's at page 99 of volume 4A, paragraph 2, small b. And then statute 8, that is members of the court, was amended.
Statute?
8, which is members of the court, was amended. That's in 4A at 102. Page 102. And then the other was all existing members of the court and executive council were ceased to hold their office. That's at page 105, volume 4A again, paragraph 10. Right. This was an emergent situation, and This then in 65 was challenged, not by AMU, not by anybody else, challenged in a PIL petition, which resulted in Basha in 1968. The Old Boys Association were not parties, AMU was not party.
This challenge, I think, include 1951 amendment also.
Yes, yes.
Both.
But Basha said 51 really is not too relevant. 65, both were under challenge. What happened thereafter, and this is very interesting with us, during the court, when this came up in Parliament, and at that time, Mr. Chagla made a statement, which I give it to your lordships. That's in volume 4C. Yeah, 4C 1325. That's important for us.
4C page 1325.
25.
Mr. Chagla is the Minister of Education.
Yes, correct, Mullah. At 1325, volume 4C.
ये बंद कर दो एक मिनट।
I didn't forget it.
Because Malaz Ali Awar Jung was then the Vice Chancellor. Malaz, there was an agitation because the institutional, remember Malaz, there's a school there. There's also institutional reservation that was reduced from 75 to 50%. There was a huge agitation all over the country. And the Ali Awar Jung was injured in the process and he was manhandled. So therefore, as a temporary measure, they sort of said, we must stop this maladministration. That was the reason for this. But kindly see, Malaz, at this, at volume 4C, page 1325. What Chagla says, Malaz, in Parliament. So that's it. My lords have.
Yes.
Now kindly see, Millets, Mr. Speaker, on the right-hand side. As we all know, we are facing a very serious crisis just now. There is aggression, there is undeclared war. We should do everything in our power to maintain communal peace and harmony. We should not say a word which will interfere with the harmony which exists and which should continue to exist. Today, we should think of ourselves not as Hindus or Muslims, but as Indians, one and all. I wish, Malad, this reverberates, in India as we stand here. Now, I am a great deal in agreement with what Mr. Mukherjee said. I have said this before and I repeat it. I repeat it with all the emphasis I possess that this bill will not in any way affect what Sri Mukherjee chooses to call the special character of the university. The Academic Council has not been interfered with. This bill does not touch the academic studies in the university. The academic studies will go on as they are. I also reiterate what I said before, that this is a temporary measure. Kindly note that. An emergency measure, and a permanent bill will be introduced as soon as possible, if possible in the next session. Then next he says, it should be a symbol. Oh, sorry. It should be a symbol. It should be a symbol of Muslim culture in the context of secular India. It should be an example to the rest of the world how different communities can preserve the glory of Aligarh. I know it has made a great contribution to our academic life, our scholarship, and our nationalism. I want to assure this House that I have brought in this ordinance and the bill as a temporary measure in order that Aligarh should be strengthened and should become a modern progressive university, that it should be a shining light not only in India, but abroad of our great composite culture.
What was Mr. Shyama Prasad Mukherjee's objection to this? When he says Mr. Mukherjee, that was...
This is 65, sir.
H.N. Mukherjee.
he was back.
H.N. Mukherjee.
When did that?
And some other Mukherjee, not Shyama Prasad.
11 it's
What was the objection actually?
311, Malas.
311?
1311, not
1300.
What was the objection actually?
Yes. There is a misgiving in many Muslim minds, whether rightly or not, is a different matter, that the special character of Aligarh is likely to be violated. That's the objection. 311.
This is Hirendranath Mukherjee.
1311. Because what happened was the election, executive council was backed by the nominees of government. Would have been packed by, because that's what 65 allowed that to happen, because everything was abolished. So there was a misgiving that if you pack the executive council with nominees of the government, what happens to the character of the university? So in this context, there is a misgiving in many Muslim minds, whether rightly or not is a different matter, that the special character of Aligarh is likely to be violated under the new arrangement. Shri Chagla has been a judge, and you, sir, also have been in that elevated position, and you know of the judicial maxim that justice should not only be done, but it must also appear that it is being done. It is the government's responsibility to show Muslim opinion all over the country that this apprehension is wrong. I know that Shri Chagla is right insofar as he is trying to put a real secular democratic complexion to Aligarh University, but if this misapprehension has arisen in the minds of many people, about all of whom we cannot be sure that they are reactionaries,
He was in support of Justice Chandra.
Hmm. Community.
When your lordships are on that page, if your lordships can see the initial part of Mr. H.N. Mukherjee's at page 1312. One page possibly is missing, my lord. We'll place it when our turn comes.
1312. Yes, it is there.
No, one further page. Anyway, I'll point out.
Just since we were on this, we are reading at 1312. Which part do you want us to read, Solicitor?
The initial debate, my lord, initial speech, or my lord, initial address
It's there.
of Sri
right
H.N.
there.
Mukherjee.
1311.
Yes.
1311 is also there.
And
On the
Raja
left side.
Mahendra Pratap Singh have all been brought up in Aligarh. Besides, Aligarh is not merely a foundation set up by the minority community. It is a foundation which the whole country has taken to
Fine.
its heart. And that is why today we find so-and-so non-Muslim students and so-and-so foreign students in Aligarh. The reputation of Aligarh is not merely the responsibility of Muslim community. The reputation of Aligarh is something which the entire country has got to look after.
I
This
agree
is
entirely.
precursor to entry 63. But
Oh,
there is one
one
more
second.
passage we'll place
That's not good.
when our turn comes.
Read that portion, last portion at page 313,
Last portion is 1313.
1313,
Yes.
for that purpose.
We have in regard to small matters, that's the one. We have in regard to small matters here and there. Let us forget what particular things we can bring up against government on particular issues.
For that purpose, I want to.
For that purpose,
On the right side.
on the right side,
Or you can start from little above also, that will.
1313. Yes, I'm reading that. Yes.
For that, says.
For that purpose, I want Mr. Chagla to reiterate more emphatically some of the assurance he has given and to seek to remove persistently by repeated effort the misgiving which continue in the minds of many Muslims in our country, all of whom I am not ready to brand as reactionary, that this legislation is going to hurt the Aligarh institution and to hurt the interests of the country. And Mullahs, there is no doubt, Mullahs, that this institution is not just for minorities. It is founded by minorities. It's for India. It's all encompassing. We are at the moment, whether it was founded by the minority or not, that's the question. In fact, if your lordship looks at this page, kindly see 1311, kindly see the last two paragraphs, we have swallowed a bitter pill, the principle of nomination, because government could have nominated. And all that kind of thing, the exclusion of representative of teachers in the court and the executive council and so many other items into which I need not go, but we have swallowed a bitter pill only for the time being so that the regular medicine follows a little later. I wish also to say that it is time when we discuss a matter of this sort that Muslims and Hindus and all, we remind ourselves of the role of Aligarh Muslim University in the context of the composite culture of our country. Aligarh has been a symbol cherished by Muslims, no doubt, more than any other people in India, but it is cherished also by the rest of the Indian people. In the traditions of Aligarh, there have been many bad things, no doubt about it. Good and bad are mixed together as far as the traditions of Aligarh are concerned. So, Malad, it represents composite culture. It is founded by the minority. It's an institution of excellence. There's no doubt about it. But Basha says...
Only one interjection, Malad, only one. Something is missing, therefore. You have placed on record the proceedings of the Parliament, Lok Sabha, dated 3rd September 65.
Yes.
And 6th.
Yeah.
There is one proceeding before that, that is 2nd September, the day prior,
Okay.
which I have quoted, my lord, in my written submissions, verbatim, at page 111.
Okay. But read it so that I'm also sort of educated.
It's, I'll read it, and it's in 111 of my written submissions,
please, if you read it.
which I believe should have been placed.
Yeah.
Lord, your lordship gets, my lord, my written submissions, page 111.
Volume 2B.
Volume 2B, I'm sorry, volume 2B,
2B.
page 111,
You're referring to which date, Mr. Mehta?
2nd September
2B.
65. Well, what is placed is from 3rd September,
No, we'll see 111. I've got it.
but there is one which is missing, my lord. I am sure inadvertently, but this is what.
Have you placed the 3rd September inadvertently, not placed it?
2nd September.
Have you placed 3rd September inadvertently?
Yes. We placed everything.
Yes.
Please. Speech by Justice retired MC Chagla, then Education Minister. Your lordship gets, my lord?
Page 111.
Yes. 111 at the foot.
I'll just see it.
I'm sorry, I'll wait till Mr. Sybil finds.
No issue at all. Yes. Now,
Speech by Justice retired MC Chagla, then Education Minister. My submission to this House is that Aligarh University has neither been established nor is being administered by the Muslim community. It is not a minority institution in the sense in which Mr. Anthony suggests. That is Frank Anthony. I will give him the reasons. You had first the Muslim college which was founded by Sir Syed Ahmad. Sir Syed Ahmad has asked the British government.
this is entirely contrary to what he says, Malad, on the 3rd of September,
Can't contradict what he
for which we
said
have the
there.
debate.
He is introducing the bill as an education.
One second.
Anyway, my lord, I'll in my
Is it
turn.
not entire?
Do we have the entirety of the discussion of the 2nd of September? Where is that?
We will place it, my lord. We have quoted it, but we'll place it.
I mean, have you quoted the 3rd September? And 6th September?
It's on record.
Maybe inadvertent.
No, it's on record, therefore not quoted.
I see.
This was not on record, therefore it is quoted.
Right.
But I'll place it, my lord.
If it's on record, it's on record. Then on 2nd September, it's also on record.
Second,
Anyway,
it's
Malad,
not on
we are
record.
not concerned with this. Malad.
It's a small issue, but if we look at it that way, but 2nd September, according to me, is an important piece of, my lord, parliamentary debate, which is not on record. I'm not, my lord, imputing any motives. That's all.
Well, your lordship notices Chagla says quite the opposite on the 3rd of September. And he's the mover of the bill also. So what does it, how does it take the matter further? I was only indicating how the reference came about, Malad. So I'm just only for that purpose. And Malad, what's
Is on.
See, when did the Indo-Pak War break out in 1965?
5?
September 65.
We'll check up and see, my lord. Often it may not be an accurate statement.
I think.
Both of us will check up and see.
Hi, Mr. Chagla says in the 3rd September that we are in a situation of an undeclared war. That part which he says.
Undeclared war has continued from beginning till date, my lord. But I'll check up, my
The
lord, what
first
is the
way-
context in which he says?
Because that sheds some light on the purpose of the amendment then.
Correct, correct. That, in what context, my lord, it was?
And this amendment,
We will check up, my lord, and we'll correctly assist you.
Malaj, in fact, the council, the executive council was 100%
So
non-Muslim.
it's on record, my lord. This,
100%.
my lord, I'm sorry.
That was the fear, that you are changing the whole character. They were then reduced later to only 3 to 5.
My lord, we have placed on record the entire debates, my lord, with our documents, my lord. That is, my lord,
It's okay, it's okay.
2F, it's not okay. You can't miss one important page. So, Lord, it is page 224 to 365.
I say, we shouldn't get into all this. The court has to decide whether it was founded.
Only saying you can't selectively place the parliamentary
Have you
debates.
quoted
That's
the
all.
September 3 in your note? You
But-
haven't.
Sybil, at the end.
What's the point of all
At
this?
the end, Mr. Chagla says, I say that this institution was not established by the minority, nor is it being administered by the minority community. That is the legal position as far as Article 30 is concerned.
Yeah,
So it appears the position of the then law minister, the Minister for Education
Yeah.
was that this was not an Article 30 institution.
correct. And the government defended that position in Basha. The government defended that position in Basha. Correct, Malaj? Then came the 81 Act, and the government is not defending that position. Malaj, if there's a parliamentary, that's why I made that comment yesterday. If there's a parliamentary act, government has to defend it. It can't say no. We're also defending the act in 65. Once you make the act, Malaj, you change it, you will have to say. What choice do you have? The minister has to say. Malaj, if we move a bill, Malaj, as a minister, we'll have to defend it, no? And we are moving the bill saying that the executive council can be nominees of the government. And if they are nominees of the government, Malaj, then the whole character of the Muslim of the institution goes. So the minister has to say this. So that doesn't answer the question. The parameter, why and how it is a minority institution has to be judged on the parameters of the law laid down by this court.
Yes.
When opinions of court can be wrong, certainly opinions of ministers moving a bill can be wrong, Malaj. I mean, there's no sanctity to that. The sanctity is to the law and to the constitution. That is why, Balaj, because of these provisions, it was challenged. This 65 Act was challenged and upheld. And Mr. Daftari argued for the government, saying that it is right. Surely, Malaj, the minister's contradictory opinions can't be the basis of a judgment of a court. That certainly is settled law now.
You can't quote one part and not.
No, you're right. I'm not disputing that. I'm not disputing what you're saying. You will read the other part and I will read this part, right? Yes,
Based on-
that's all right. It is already on record.
It's not on record. We have placed the entire thing on
I
record.
see, but you haven't quoted it.
Anyway,
Send it as you haven't given it to us.
No, it's there in volume 4F.
We don't have it.
4F.
We don't have it. It's not uploaded.
It's there in the common file. Your nodal council has it. 4F. Let him say it's not there. They
We
have
don't
it
have it.
since then, since long.
No, Malas, kindly let's move on with the
Yes,
matter.
Mr.
That's
Yes, Mr.
the better way. That's the way.
Debate is not in question. I'm just trying to give the Malas, let's go back to what I was saying, Malas.
Sorry, 72 amendment,
Yes,
that brings out, what exactly happened. It appears that there was student unrest on the
yes,
campus.
yes,
At that point, they brought in a temporary measure.
yes,
The idea was to bring both Aligarh Muslim University and Banaras Hindu University at par in
Yeah.
terms of the statutory provisions.
right,
Government UGC appointed a commission chaired by Dr. P.B. Gajendra,
yes,
former Chief Justice of India, to go into the functioning of AMU. That Dr. Gajendra submitted his report. We may have we may want to look at the report which
Sure.
was submitted by Dr. Gajendra
sure,
on what did the report really indicate.
right,
Following which, by the 1965 amendment was always intended to be a sort of a pro tem amendment
That's
until long-ranging amendments were brought into the
Right.
provisions of the
Right.
statute.
So then, Malas, between 65 and 81, I go back to my list of dates, Malas, the point of which is that volume 4.
See if you look at
Note, yeah, what?
essentially.
Yes. I'm coming. So, Malas, we come to 1965 and the decision in 1968. Then between 68 and 81, there was a movement to protect the rights of Aligarh Muslim University as a minority institution. And then the 1981 Act came. So you have a hiatus between 65 and 91. 68 and 91.
Just give us the
81,
page
sorry.
number of the 1981 Act so that we'll have it all in one place now. Volume 4A,
4A, volume 4A, Malas.
page.
Page 147. And Malas, in that context, if your lordships don't mind, that that judgment is not on
That's
record. Yeah, there's a judgment of this court in 1998, 6 Supreme Court cases. Maybe they can get it. No, they could send it. 1998, 6 Supreme Court cases, 674.
That report might be very much.
Yes. Yeah, good. Yes, paras 12. Yes. 11, 12, 13.
Appellate is there on this.
I got it. This court which is on your lordship's screen, Malat. 1998, 6 Supreme Court cases, page 674. Kindly come to 679.
679 pages.
679. This was in the context of a minority school, Malat. Maharaj, minority school in paragraph 11, Maharaj, your lordships will see, is defined in 2(5) of the Act. Minority school means school of their choice established and administered or administered by such minorities as have the right to do so under clause 1 of 30. Counsel for both sides conceded that there is no provision in the Act which enable the government to declare a school as a minority school. If so, a school which is otherwise a minority school should continue to be so, whether the government declared it as such or not. Declaration by the government is at best only a recognition of an existing fact. This is very important. Article 31 of the Constitution reads as such, I won't read it, Maharaj. When the government declared the school as a minority school, it had recognized a factual position that the school was established and is being administered by a minority community. The declaration is only an open acceptance of a legal character which should necessarily have existed antecedent to such declaration. Therefore, we are unable to agree with the contention of the school that the school can claim protection only after the government declared it as a minority. We are not dependent on the declaration, Maharaj. It's what happened antecedent to the declaration that will determine whether it's a minority institution or not. So whether the minister says it or the statute says it, none of that is relevant. What is relevant is the factual position existing antecedent.
Then came 81.
And then you go back to, yes, this. We come to the 91 Act, Maharaj. Your Lordship is aware of that Act. Then comes, Maharaj, on 26th of November, 1981, there's an order passed in Anjumane Rahmaniya, which is writ petition 547, 554 to 57 of 81, which is referring Basha's judgment to a 7-judge bench. That's on November 26. This is important. That is November 26, 1981. The 1981 Act was on December. What's the date of it? 22nd December 1981. Just 1 month after this. Yes, was 22nd December. Now, let's kindly look at that order of Justice Fazal Ali. Volume 3A. Page 209.
Fazal Ali J was in a bench of 2 or bench of 3?
2.
2 referred the matter to 7?
Yes, this is.
That's one of my contentions.
No, that's all right. You can. Yes, 3A, Maharaj. Page 209.
Yeah, Chief Justice.
(209), volume 3A. Kindly have a look at that. Kindly note, it's writ petition 54 to 57. It will have some bearing. This writ petition 54, 57 has some bearing. So kindly, note that. Let's kindly, if I can read that order. After hearing counsel for parties were clearly of the opinion that this case involves two substantial questions regarding the interpretation of 30 of the Constitution. The present institution was founded in the year 1938. That's the other institution, and registered under the Societies Registration Act in 40. The documents relating to the time when the institution was founded clearly shows that when the institution was established mainly by the Muslim community, but there were members from the non-Muslim community also who participated in the establishment process. The point that arises is whether Act 30, Article 30, it should be not Act, or Sub-Article 1 of the Constitution envisages an institution which is established by minorities alone without the participation for the factum of establishment from any other community. On this point, there is no clear decision of this court. There are some observations in Basha, but these observations can be explained away. Another point that arises is whether soon after the establishment of the institution, if it's a registered society under the Societies Registration Act, its status as a minority institution changes in view of the what principles laid down in Basha, because then it gets merged, as incorporated. Even as it is, several jurists, including Sirvai, have expressed about the correctness of the decision of this court in Basha. Since the point has arisen in this case, we think that it is a proper occasion when a larger bench can be considered the entire aspect fully. We therefore direct that this case may be placed before the Honorable Chief Justice for being heard by a bench of at least 7 judges, so that Basha's case may also be considered. And the points that arise in this case directly as to the essential conditions or ingredients of the minority institutions may also be decided once for all. A large number of jurists, including Mr. Sirvai, Learned Counsel, Mr. Garg, and Learned Counsel for respondents and interveners have stated that this case requires reconsideration. So therefore, liberty was granted. So this happened, Malad, in November 81. The act comes on December 22nd, 81. In the meantime, on the ground, nothing has changed, Malad. When Chagla made that speech in Parliament, he didn't implement the 65 Act as that was sought to be done. He didn't do it. Only, instead of all it being packed, only 3-4 members remain of the non-Muslim, of nominees of the government. Then, that is the Old Boys Association, which was set up in 1899. Sorry. Started a whole movement that, look, this is all wrong. This is all wrong. You must have an act. That's how the act came into being. And I don't want to digress into any other issue, but the fact is that this is a pre-Constitution Act. It's a 1920 Act. Without going into usurpation of judicial power, that's all, according to me, an irrelevant issue. Under 372, an act can be repealed, altered.
One act.
Yes.
Did that have the effect of, therefore, then nullifying the 65 amendments?
Yes. Yes. Absolutely. So this whole argument of usurpation, the Constitution gives the Parliament that right. But I don't want to argue it because it doesn't arise in Basha. But since,
Basha involved a challenge to the 65 amendments.
That's right. And 51.
And 51.
Yes.
And the 1981 Act then restored the position by, I don't know whether it destroyed
it didn't exactly restore. It was a new legislation.
But it nullified the effect of the 1965 Act.
That's correct. But that doesn't matter because the 372 gives power to Parliament to alter a law.
If we, will it be correct to say?
It seeks to nullify the judgment.
No, one.
No. That's not true.
I'll show. I'll show.
Will it be correct to say that in case we overrule Basha, then the challenge to the 65 amendments will come into the foray?
No, Malad. The point I'm making is somewhat different, Malad. We are challenging Basha on the day when it was decided. Therefore, none of this is relevant, according to me, because the reference is only whether Basha was rightly decided on the day it was decided. That's the reference. But all these matters are now being brought in by the other side. All these matters saying it's an institution of national importance under. That's right, I know that, I know that. To do is whether Basha is rightly decided or not on the parameters of the law under Article 30. What your lordships are not asked to decide. Now they have brought in entry 63, but it was not argued in Basha. Are we to argue something else now? They brought in statutes that are minority statutes that are normal institutions that are now incorporated under the National Minority Commission Act. Are we to look at that? That's all irrelevant. Wholly irrelevant. This is a decision of 1968 based on an act of 1920, which your lordships are asked to decide whether it's right or wrong. Otherwise, there'll have to be pleadings because he has made some averments which are completely wrong. But you can't have pleadings in a reference. He's giving all kinds of examples. Land was given is completely wrong. But we are not into that. That's why I'm not arguing any of that. That's why I'm not even meeting that argument. But that whole argument is sought to be diverted to issues which are not before Basha, issues that don't arise under the 1920 Act.
All right, what else?
So, Manoj, I'm quickly trying to go through it. So, Manoj, no. Then what happened was, just Manoj, kindly. I'm trying to, Manoj, finish as quickly as possible.
Mr. Civil, just one simple question.
Yes.
Did Dawoodi Bohra make it applicable prospectively, the principle laid down in Dawoodi Bohra? Or is it applicable retrospectively?
I'd have to, Manoj. I
Just
don't want to answer
find
that
that
question.
out.
I don't want to answer that question right away. I don't want to answer that question right away. I will certainly, Manoj. So, Manoj, what happens thereafter? And that's then comes Manoj. Then comes TMA Pi. Now, this 54 writ petition 54 to 57 is tagged on to TMA Pi before 11 judges.
The order also says that.
That's right. So, Manoj, this whole argument that you could refer it, two judges could not refer it, of course, Manoj, the principles of law at that time are different. But be that as it may, Manoj, it was tagged on before 11 judges. Writ petition 54 to 57, you'll find that order, Manoj, in 3A, page 216. Oh, 216. 552, Manoj, sorry. Yes.
In 5A.
In 5A, 552, first line. Sorry, Manoj. Yeah, but I will then now give the reference after this Google reference.
What specifically says
Court rules, Malad. It says, where in the course of a hearing of any cause, appeal or other proceeding, bench considers that the matter should be dealt with by a larger bench, it shall refer the matter to the Chief Justice, who shall thereupon constitute such a bench for the hearing of it. Rules, Order 6, Rule 2.
And Rule 1 anyway preserves the power of the Chief Justice.
That's correct. And Malad, even Justice Gogoi's reference was 3 judges, Malad. Even Justice Gogoi's reference was 3 judges. So this objection that, it can't be referred, Malad, is all.
And though Chief Justice Gogoi was sitting on the judicial side,
Yes.
as Chief Justice, his powers are
His
preserved by
powers
Order
are
6
there,
Rule 1.
yes.
to constitute
And then
larger
PM
bench.
If bench consists of the Honorable Chief Justice, it can be.
Why can't 2 judges say refer it to 7 and refer the matter to the Chief Justice?
Anyway, but I'll not reduce the debate to that level.
But
I'm not going to
taken
raise that.
objection.
We have addressed your lordships on marriage. I will also have
Correct,
lordships.
because initially he did, therefore I.
The matter is too important for us to really
Yes,
rest the judgment on
exactly.
it.
What I initially
So,
said
we
was,
can't be oblivious of the fact, reference of 1981,
certainly,
tagged on to 11 judges,
certainly. But I'm,
left open in TMFI,
Yeah.
then noticed in Justice Gogoi in the referring order of 2019. But Mr. Sibal, there's one which
One
we
thing,
must
Manoj, I
also
mean-
bear in mind,
Sure.
that when Chief Justice Gogoi's bench made that reference to a larger bench in 2019, unless...
No, but
I have not raised it.
Then,
I have not.
when the pleadings are incomplete, then there are no pleadings to this effect.
But we have for instance, we have a parliamentary amendment of 1981.
Correct, but there are no pleadings for that.
I will show from
How
the
will-
record.
how will it be decided?
It's whatever I have said is a part of the
Clear on
record.
one thing, Malad.
Only one. Give me a minute, just to
Sure.
answer the court.
One.
I have not raised that technical point. Initially, I said that the scope of reference is not redeciding Basha on facts which are concluded. The way they are arguing, that's what I have said.
No.
I have
In
not-
fact, Malad, he said that's an inter-parties decision. It cannot be altered by a bench. That's his argument.
That's
In the written
But not this,
summation.
the reference could not
Just
have been made
one
as
second.
Yeah, Mr. Sibal, Mr. Solicitor, we are in a combination of 7.
Yeah.
We decide a constitutional matter. Perhaps it would be inappropriate for us to look at facts for deciding the
Yes,
minority
yes,
character.
yes.
Who gave how much land,
Yes.
whatever is already on the record, what was brought on the record in Badshah,
And Allahabad High Court, whatever's in the record from the Allahabad High Court, no problem.
So when we hear Mr. Farasat's de jure versus de facto argument, we must also keep at the back of my mind that this is a constitutional court
Yes.
sitting in a reference of 7.
That's right.
So we really have to, in that sense, confine ourselves, and perhaps there's always a temptation to try and resolve everything forever, but it's difficult, and we should be careful about doing that in a combination of 7, particularly in the absence of test facts.
My request is whatever pleadings are available in the Allahabad writ petition should be taken into account. But none of what he has
No,
pleaded
it
now
was
is
a
part of
32 petition.
Sir?
Basha was a 32 petition.
No, I'm not on that. In the Allahabad High Court, Malad, I was trying to complete the list of dates. Then this matter, Malad, 81 onwards, the act came. Then TMA, 24 years, we were granting decrees. Then in 2005, that's the next date, Malad, 2005, Malad, there was a 50% reservation for MD/MS students. That was challenged. That resulted in the Allahabad judgment, where the judge said, Basha has rightly decided, you are covered by Basha. It didn't go into anything else. So that was not strictly Malad before the court. The issue was only 50% reservation to the Muslim.
Basha upholds the 1951
Yes,
and the 65 amendment,
yes,
right?
yes.
the Allahabad High Court sets aside the 1981 amendment
Yeah.
on the ground of Basha.
That's correct.
Now, two questions will arise before us. Suppose we hold that we accept your, for the testing the argument.
Yeah.
Suppose we accept your argument and hold that Basha was wrongly decided.
Right.
Basha upheld the 1951 and 1965 amendment.
Correct.
What would be the consequence of our coming to the conclusion that Basha was wrongly decided on the amendments which were in challenge in Basha? Second, if we hold that Basha was wrongly decided, then what would be the impact of that on the Allahabad judgment? The Allahabad judgment dealt with a challenge to the subsequent amendment,
Yes.
right?
Right.
Now, if Allahabad has relied exclusively on Basha,
Right.
now
Correct.
if we come to the conclusion that Basha was wrongly decided,
Correct.
it would immediately impact upon the judgment of the Allahabad High Court,
Correct.
and therefore the validity.
By the other bench.
Actually, if Basha is upheld,
Yeah.
then
Then
the
also-
validity of the 1981 Act becomes subsidiary.
That's right. That is,
Because the 81 Act purports to restore the minority character
yes.
of the institution.
Yeah.
If it is held not to be a minority institution,
Restore,
right?
not restore, confers, according to it.
Right.
It
Whatever.
was never there, it confers.
That-
Basha says it's not there. so
That's
it
right, but that's
confers.
why we are dealing with Pasha. That's the whole the point. You can't rely on Pasha to decide on the 1981 Act.
So ultimately, our decision on the validity of Basha
Yeah.
would impact upon not just the amendment, but it also has an impact on the Allahabad
Correct.
judgment.
And therefore, Malaz, that matter will be decided by another bench. So your lordships are not going to go to all this. Malaz.
Mr. Simple, even on, suppose we even,
That's what I was trying to tell him actually.
even if you overrule Badshah on the two legal principles on interpretation of establishment and administration,
That's right. But Malaz, the 81 Act will come in the meantime, Malaz. Yeah. Correct.
and in case Badshah is overruled, then 81 amendment, they may withdraw their appeals. There's nobody.
We don't know what's
pursue
going to
it.
happen, Malaz. Litigation is part of the culture of
It's
this.
quite clear, it serves no purpose then
I
for.
know, Malaz.
serves no
Your
purpose.
lordship knows that even when in litigation there is no purpose, still there is litigation.
21.
Why?
Only.
Your lordship experiences it every day. So Malaz, Dr. Dhawan will live to argue the next case, Malaz. So Malaz, these submissions are being only divert the attention of the court to issues that are not before it. Yeah, of course, everything's.
That 81 amendment be also examined because
No,
they are not several.
Not in a
They are
reference.
not comfortable with that amendment.
No, no, we
defend
are
that
comfortable.
amendment.
It's not referred.
Will definitely have a bearing on the Allahabad High Court judgment, definitely have a bearing. Which
The
we
reference,
look at it.
the reference has emanated from that 81.
So to say that that will have, that has a direct bearing.
The reference is in that bit.
Besides Badshah, completely decides what the Allahabad High Court has decided either.
Not either.
So, if we overrule Badshah and say that AMU has a minority status in view of,
Yes.
the
is not removing the valid, is not a validating act, removing the basis of the
No difference.
overruling
No difference, Mr. Kaul, no difference at all, because once Basha is declared to be in bad law,
Right.
the position as it was before Basha in law would have to be examined. That's
Right.
it.
But as my
And therefore, 81 amendment, the reasoning of the Allahabad High Court that the legislature is directly overruling the High Court no longer remains.
that is the second part. The first part is Allahabad High Court relies on Basha.
Actually, that's a case to be-
Allahabad High Court directly relies on Basha to say what it says. And then in addition says that.
Mr. Kaul,
Has to overrule.
Mr. Kaul, Basha denies minority status to
Right.
AMU.
Right.
The 81 amendment sought to, as a solicitor, I'll put it in from your point of view, the 81 amendment sought to confer the minority status. They say that this was declaratory. We will have to decide that. Now, the fact of the matter is that if we come to the conclusion that Basha was wrongly decided,
Right.
the immediate impact of that would be that the denial of minority status to AMU was wrong. We don't agree with the reasons on the basis of which Basha denied minority status to AMU.
Right.
In which case, the reason why my brother is putting that to is this. If we overrule Basha, then the only basis for setting aside the 1981 amendment was that Parliament has merely nullified the judgment in Basha without taking away its basis. If we come to the conclusion that Basha was wrongly decided, that ground of challenge with the Allahabad High Court ceases to have any relevance.
But it has a direct impact on the decision.
Undoubtedly, but
All that I said was.
the whole postulate of the Allahabad judgment
Yes.
is that Parliament could not have, without taking away the basis of Basha,
Yeah.
overruled it by a simple declaration that they did by amending the definition.
Right.
But if we go to the source, which is Basha,
Right.
and come to the conclusion that Basha was wrongly decided,
Right.
the basis of the Allahabad judgment itself is taken away.
I started by saying.
That's right.
That what Basha is decided in has a direct impact on the Allahabad High Court judgment.
So ultimately, it all boils down to whether Basha is correct or otherwise.
That's all that I'm saying, well, that's all that I'm saying.
That's a core issue.
That's the point.
Mr. Paul said. In the High Court, reliance was squarely placed on the 81 amendment because they had a 2005 decision which was taken after the 81 amendment saying that they are giving reservation. That was the cause of action for the writ petition before the High Court. In the process of defending that decision, square reliance was placed on the 81 amendment. Therefore, the High Court went into it, looked into the factual finding in Basha saying that it is not a minority institution. Now, therefore, today it can't be that much. The telescope is put back as it were straight away to 1967 and then said, decide Basha in a vacuum, whether it's right or wrong. The difficulty is in the process of doing that, 81 is relied upon, 72 is thought to be relied upon. Please ignore 81 for a minute, Manoj. 1972 is thought to be relied upon. 72 is immediately after Basha. So with all this, I would respectfully submit when there is a reference made, the matter proceeds on the basis that the entire matter is before the court. One more aspect, Manoj. Please see the reference order. Reference order, as what rightly fell from my Lord the Chief Justice, does not confine it only to the question of Basha. He talks about the NC-MEI Act of 2006 as amended in 2010. The question is then, will the 7 judges bench completely excise from the consideration that act also? Now they are relying on the 2006 Act also as amended in 2010. So these are, in my respectful submission, my lords, issues where it has to be a holistic picture.
We are not concerned directly with 2006 or 2010 Act. That's not the subject matter of Basha. One. Number two, that has not been examined by any 2 judges bench or 3 judges bench.
I follow, my lords, but then in the reference
That's
order.
it. That's it. Now, directly making a reference over here without there being a direct, yes, what does the second order does of Justice Gogoi,
Yes,
Chief Justice
that
Gogoi
refers
does
to
is, it just narrates the history, what has happened. The questions which are there are the ones which were already.
No, not necessarily. With respect, my lords,
It will have some bearing. Why Justice Gogoi refers to it, and that is why we started by saying the scope of reference is in our own terms. The entire reference, including Justice Gogoi's order, was about conjunctive or disjunctive. Yashpal in the NSC-MI order, which Justice Surya pointed out yesterday, the issue arose was, is it established or incorporated in the UGC order? Now, there Yashpal answered it by saying it's and. The 2010 amendment which was brought about later to the NSCME Act also said it's and not or. In that context, Justice Gogoi, while dealing with the history of what has happened since right from the beginning of the only issue, for 50 years, no decision ever questioned Basha's decision on the individual finding on administrative or establishment. The only question which is being raised repeatedly, like Rimanya downwards, is establish and incorporate disjunctive or conjunctive. And I'll show that in my turn comes my notes. That's why this Gogoi, in the reference order of 2019, categorically relies on Yashpal to say that Yashpal, NSC, NCMI, and UGC dealing with the issue of or versus and, not on the issue of my AMU being a minority as administered or established, only on the adjunctive and conjunctive issue.
Mr. Cole, the principles laid down in Yashpal will definitely have to be referred to while examining Basha. One. Two, the subsequent amendment which has direct bearing, that is 1981 amendment, say, put it otherwise. I think you can reformulate what you are probably trying to say. If the 1981 amendment is approved by the 7th judge bench, is upheld by the 7th bench, then challenge to Basha becomes academic.
I bowed down, Manoj.
Then Basha, then examination of Basha also does not survive.
Grateful. But all that I'm saying is this whole reference
Probably
to
this is what
UGC,
the issue
NSC,
arise.
NCMEI,
From that angle,
Yashpal
Mr.
was
Sibbal,
not
I'm
nothing in
sorry.
Justice Gogoi's order.
I'll answer that
It was all
straight away.
dealing with adjunctive versus
Let's
conjunctive.
hear Mr. Sibbal now. We have to wrap up.
Yes, yeah,
one
but
line.
because all this time has been.
Only
Mr.
one
Sibbal,
line,
yeah.
if your lordship.
Now, let's complete Mr. Sibbal's argument. Is almost.
I'll answer it straight away, Murad.
Yeah.
Assuming for the moment your lordship decides that Basha is wrongly decided. Let's assume, Murad. What is the consequence? That I was a minority institution at the inception.
that may not expressly or impliedly approve the 1981 amendment.
Forget 1981, Murad. Your lordships will give a declaration that I am a minority institution. That's all. Forget the 81 Act. What is it? Your lordships can't change the nature of the minority institution if you say that Basha is wrongly decided. That nature will not change, Murad, under the 1981 Act. 1981 confers something, what your lordships would already have decided. What are we talking about? So let's be clear on what the lay of the land is. If Basha is rightly decided, then the question arises whether the 1981 Act.
Whether did it take away its basis or merely nullify the.
Exactly. Then only it arises, not otherwise. Because 81 will not change the status, Murad, of the minority institution with a declaration that Basha is wrongly decided. Therefore, Murad, all this is a red herring.
All right. What more now, Mr. Sibbal?
Murad, I've been trying to finish, but what can I do, Murad?
There's always time out by the judges, so you have to always factor that in. So, how long more now, Mr. Sibbal?
Not very long, not very. I'm just, Murad, trying to, then I'll finally come on Basha and that's it. Nothing more than that. So, Murad, now the reference. If your lordship,
Yes,
you want
read the reference.
Let's read the reference of Justice Gogoi. That's at Mulad's volume
What is the date?
3A. Date is Mulad's
26 September. Or no?
12th of
Of 19.
February 12,
No, that's a Google.
2019. February 12, 2019, volume 3A, page 216. Read it, finish it, yeah.
In which case,
Sorry, Madam?
the reference order
Yes. In
is in Allahabad.
in AMU, Madam. AMU versus Naresh Agarwal. And all other connected matters. That's the challenge to the High Court order. Now kindly see, Madam. in Aziz Basha, the court, it is to our mind quite clear that 30 sub-article 1 postulates that the religious community will have the right to establish and administer educational institutions of their choice, meaning thereby that where a religious minority establishes an educational institution, it will have the right to administer that. An argument has been raised to the effect that even though the religious minority may not have established the institution, it still have a right to administer it if by some process it has been administering the same before the Constitution came into force. We're not prepared to accept this argument, and I'm not arguing it. It's completely wrong, Malas. The article, in our opinion, clearly shows that the minority will have the right to administer an educational institution of their choice, provided they have established them, but not otherwise. The article cannot be read to mean that even if the educational institution has been established by somebody else, any religious minority would have the right to administer it because for some reason or other, it might have been administering it before the Constitution came into force. The words establish and administer in the article must be read conjunctively, and so read it gives the right to the minority to administer an educational institution provided it has been established by it. We're of the opinion that nothing in that case justifies the contention raised on behalf of the petitioners that the minorities would have the right to administer an educational institution even though the institution may not have been established by them. The two words must be read together, and so read the article gives the right to the minority to administer institutions established by it. If the educational institution has not been established, it cannot claim to administer. That's what Basha held, and I agree here one. The judgment of the Allahabad High Court, which is under challenge in the present appeal, rejects the prayers made on account of the decision of this court in Basha. The issue arising in Basha, Supra, was referred to a 7-judge bench by an order of this court on 26 November, which is Justice Fazal Ali's order, which is writ petition so-and-so. The aforesaid writ petitions were heard along with other connected matters in TMA Pi by a bench of 11 judges, and the judgment in cases reported in so-and-so. Question which was formulated for answer in TMA Pi, which coincidentally reflects the questions referred to by order of this court of 26 November, passed in writ petition so-and-so. What are the indicia for treating an educational institution a minority educational institution? Would an institution be regarded as a minority educational institution because it was established by persons belonging to a religious and linguistic minority, or it's being administered by persons belonging to a religious or linguistic minority? However, the bench did not answer the question, stating that it will be dealt with by the regular bench. The order of the regular bench passed on 11th March, which for reasons that we need not dilate, did not answer the aforesaid question. The said facts would show that the correctness of Basha arising from the decision in Basha has remained undetermined. That apart, the decision of the court in Yashpal and the amendment of the NCMEI made in the year 2010 would also require an authoritative pronouncement of the aforesaid question formulated, besides the correctness of the view in the judgment of this court in Basha, which was been extracted above. Ordinarily and in the normal course, the judicial discipline would require the bench to seek a reference of this matter by a 5-judge bench. However, being regard to the background as stated above, when the precise question is already referred to 7 judges and was, however, not answered, we are of the view that the present question set out above. So we refer to set out above. What is that? So clearly, Manoj.
Mr. Sibal, Justice Gogoi has referred to in the referring order, Chief Justice Gogoi's referring order, refers to 2 aspects.
Yes.
One, the correctness of the decision in Basha has been undetermined, has not been determined.
Correct.
Second, question 3A, which was framed in TMA 5,
Right.
was not answered.
That's correct.
So that's why if you will just revisit that once observation there, para 9.
Yes, that's the one. Manoj.
Para 9.
That's the one. Amendment to the
Para
NCM.
8 actually will see
Para
first.
8, Manoj. The said facts would show that the correctness of the question arising from the decision in Basha has remained undetermined.
Now we'll go to para 9.
Then 9. That apart, the decision of this court in Yashpal and the amendment of the NCMEI made in 2004 and made in 2010 would also require authority to pronounce the aforesaid question formulated as set out above, besides the correctness of the view in Basha. Now, Manoj, my answer to your lordships is very simple. If your lordships decide that Basha was wrongly decided, nothing else arises. Nothing else arises. Yes.
3 questions which Justice Gogoi had in his mind.
Yes.
1, the correctness of the decision in Basha.
Correct.
2, question 3A, which was referred to in item 3A.
Yes.
In fact, he says that 3A covers the correctness of the entire decision, the 26/11/81 order.
Correct. Correct.
And 3, the impact of Yashpal.
Correct. Now, Manoj, as I said to your lordships, and I'm saying it time and again, if you hold that it was established by a minority, then nothing else arises. Sorry?
Nine talks of both the things.
No, I know, but I'm on another point. Your lordship is right. I'm not disputing that, Mullahs. My request to your lordship is, yeah, assuming, Mullahs, your lordship finds that Basha has wrongly decided and 1981 is unconstitutional. Where does it leave us? It will leave us nowhere. Then we'll still be a minority institution.
We have to rephrase the reference because keeping in para 9 of the order we have just read out.
Yeah.
Yashpal and 2004 Act amendment in 2010, both are required to be examined, and in what context? On the aforesaid question formulated.
Therefore, Mullahs, my request to your lordships is you first examine whether Basha has rightly decided or not. Render a judgment there. If you come to the conclusion Basha has wrongly decided, the second question need not be gone into. If you come to the conclusion Basha has rightly decided, then, Mullahs, in any case, the 1981 issue will have to be.
Besides the correctness of the view.
Yes.
Besides mean in addition to.
In addition to. Therefore, Mullahs, we have to move, Mullahs, in a way, Mullahs, that in fact it decides the matter one way or the other. Then you can decide the 81 issue. If you decide against me on Basha.
All right, now what remains now, Mr. Sibal?
NCMEI Act, amendment to the NCMEI Act would require an authority, the amendment.
On the question formulated.
Yes. No, Mullahs, this is not the NCMEI Act.
That amendment.
And NDCR.
Yeah, that
That is the first question.
What are the indications?
Change the landscape, judicially, something.
Visible?
Now, Mullahs, actually, if you look at 9, Mullahs, actually, we've not fully understood the way 9 is formulated. Kindly do read it 9 again. That apart, the decision of this court in Yashpal. Now, Yashpal dealt with bogus universities in one building. And the amendment to the NCMEI, what was that amendment? Malad? Originally, university was excluded. Now university is included. That's all. And how that amendment will impact the question formulated.
Mr. Sibal, also we have to bear in mind, I mean, with a little bit of experience, that when you refer a matter, you're not looking at the matter threadbare. Sometimes you are. Suppose we were to refer it to a bench of 9. Now we have heard it for the last, so we are now completely in season of all the
matter.
No, but what we are saying is normally, otherwise when you make a reference,
Yeah.
you refer on the basis of, without really much ado, without going into a very detailed consideration of the matter. Therefore, the words of a referring court never bind the court to which it is referred.
That's
Because you are a larger bench,
Yes.
you have to reformulate the questions
Yes,
to
exactly.
bring finality to the dispute.
Exactly.
Insofar, but at the same time, there are some parameters which you keep in mind,
Of course.
which is you can't go beyond the pleading. You are
Exactly.
answering basically a question of law.
That's correct.
Before
That's all that I'm saying. But even this amendment, it says to the, would also require an authoritative pronoun on the aforesaid question formulated. What is the aforesaid question formulated? Whether Basha is rightly decided or not. All relates only to Basha.
But Mr. Sibal, equally, just as you are saying, don't freeze Basha in point of time. Look at the law laid down by our court before Basha
Yes.
and after Basha.
Yes.
Because rightly, you've also relied on Stephens and, the TMFI.
No, but that's it, the declaration of the law from the beginning.
Likewise, we can't freeze our version of whether Basha is correctly decided without reference to the entirety of the statutory history governing AMU.
But
We can't say we'll freeze it as of the statutes as in existence one day before Basha was decided.
that's
That
not-
cannot be a,
No.
that cannot be a correct approach for
The point is, Malad, the 1920,
We have to look at the overall lay of the statutory scheme in relation to AMU.
Malad, which we have placed before you.
Yes.
We have placed before you. We are not questioning anything that happened after that. Only reaffirms the fact the 81 only said that it was a minority institution. Now, whether that was right or wrong is a separate issue.
That's your argument and that's your point. That look, even if you were to look at the 81 amendment, 81 reinforces
Yes.
what according to you is the correct position even before 81.
That's right. So, Malad, therefore, you can look at
And
it.
we'll
And
judge
if you
on
decide
that.
against us, Malad, then that question will arise. So, Malad, let me quickly now finish with this, Malad.
Yes.
Now, having said that, Malad, kindly now see what Basha decided. So we know we've done that. Now, Malad, what are the correct statements in Basha? Kindly look at factual aspect, Malad, so that I don't waste your lordship's time. Kindly come to page 9 of volume 3A. Yes, it says, kindly see placitum A and B, statement of fact. Further, it seems that the existing MAO college was made the basis of the university and was made over to the authorities established by the 1920 Act for the administration of the university, along with properties and funds attached to the college, the major part of which had been contributed by Muslims through though some contributions were made by other communities. This is a factual statement, Mullahs. Correct. Nothing wrong with that statement. It only shows what? That we are the ones who set up the university. And Mullahs, that 30 lakh today, if translated today, into 2006, as translated, it would be 280 crores. And today it'd be 500 crores. So, Mullahs, Basha accepts. Is the MAO college was in existence. It was made the basis of the university. And whether the properties and the funds attached, that means everything in the college was handed over to the university. And the section itself says so. So the genesis of it is correct. That Basha affirms. Now, so it was, now number 2 is come to page 14 now. I'm just indicating the facts that are accepted by Basha itself. It says that brings us to the end of section 19, sections of 1920. Actually, Your Lordship has, sorry, it's not that. Page 14. Yes, kindly. The next paragraph between B and C, sentence starting. the annexure to the 1920 Act. Lordship has that? Between B and C at page 14.
Yes, the last
The
sentence.
annexure to the 1920 Act gives the names of the foundation members of the court 124 who were all Muslims and who were to hold office for 5 years for the commencement. So, the factual statement, correct, indicates the genesis. Then come to page 15. Third paragraph, fourth line, between placetum C and D. It is remarkable that though the proviso to 23(1) was deleted as far back as 1951, there was no challenge to the 51 Act till after the ordinance of 65. Factually correct, Malaz? Nobody challenged it. The reason for this might be that there was practically no substantial change in the administrative setup of the 1920 Act, and it is only when a drastic change was made by the ordinance of 65 followed by the Act that challenge was made not only to the 65 Act but also to the 55 Act, insofar as it did away the proviso of 23(1). So factually, Pasha acknowledges that nothing changed, despite the 51 Act. Acknowledges that fact. And what was the proviso? That all members of the court shall be Muslims. That's the third factual issue. Fourth, page 16, top of the page. The statutes was right, placetum A. May I read it? The statutes were also amended and many of the powers of the court were transferred by the amendment to the Executive Council. Further, the constitution of the court was drastically changed by the amendment of the 8th statute, and it practically became a body nominated by the visitor, except for the Chancellor, the Pro-Chancellor, the members of the Executive Council, who were ex officio members, and 3 members of Parliament, 2 to be nominated by the Speaker of the House, and 1 the Chairman of the Council of States. Changes were also made in the Constitution of the Executive Council. Finally, the 65 Act provided that every person holding office as a member of the court or the Executive Council, as the case may be, immediately before the 20th day of 65, shall on and from the said date cease to hold office. It was also provided that until the court and the Executive Council were reconstituted, the visitor may by general or special order direct any office of the university to exercise the powers. So this tells you, this is the reason for challenge of the 65 Act. Correct, Malaz? That's why it was challenged. Now come to page 17, top of the page, placetum A. Yes. The words establish and administer in the article must be read conjunctively, and so read it gives the right to the minority to administer an educational institution, provided it has been established by it. So, that's the statement of the law, provided we have established it. So that's correct also. Then 17, at page 17, placetum F. We have therefore to consider whether Aligarh Muslim University was established by the minority community, and if it was so established, the minority community would certainly have the right to administer it. So clear, Malaz? That's what they say. So test is only of establishment, nothing more, and at the inception. Correct? So that's page 17. Then come to page 18. No, before we do so, the placetum paragraph starting before we do so. Before we do so, we should like to say that the words educational institution are a wide import and would include a university also. Please, Malaz, mark that. That's the contradiction in Bhasha. Let's kindly see. I'm sorry, I should have read the first paragraph. We shall have to examine. We shall have to examine closely what happened in 1920 when the act was passed to decide, firstly, whether in the face of that act, it could be said that the Aligarh University was established by the Muslim minority. According to me, a wrong question asked, and you got the wrong answer. He says, if by virtue of that act, can you say that the university was established? And that's the answer he gives. So we should have to examine what happened in 20, when the 20 Act was passed to decide, firstly, whether in the face of the Act, it could be said that the Aligarh University was established by the Muslim minority. Secondly, whether the right to administer it ever vested in the minority. It's also wrong. I've shown to your lordships the provisions. Court was all Muslim. Money was there. Executive Council, Academic Council. In the Executive Council, out of 30 members, 23 were Muslim. That's administration. In the Academic Council, the majority were always Muslim. That's the administration. And three, even if the right to administer some properties that came to the university vested in the minority before the establishment of Aligarh, whether it had surrendered when the Aligarh University, what does that mean? Surrender means what? Whereas if we want to become a university, we'll have to transfer all rights and obligations to the university. There is no other way to become a university. So where's the question of surrender? By virtue of the statute, to be called a university, we have to transfer all rights and obligations of property, teachers, students, everything, which is exactly what we did. Then, before we do so, we should like to say that educational institutions are a wide import and would include a university also. This was not disputed on behalf of the union.
University is an educational institution.
That's right, not disputed. So it comes under 30 sub article 1. That's the point I was making, Madam. Union of India, and therefore it may be accepted that a religious minority had the right to establish university under 30th Article 1. The position with respect to the establishment of universities before the Constitution came into force in 1950 was this: there was no law in India which prohibited any private individual or body from establishing university, and it was therefore open to the private individual or body to establish university. There's a good deal in common between educational institutions which are not universities and those which are. Both teach students and both have teachers. But what distinguishes a university from the other is that a university grants degrees of its own while the educational institutions cannot. Then come back, Malas, this is what he said. Now, Malas, can we come back to H. Placitum H. The importance, kindly see. Last, just above H, the importance of the recognition of government in matters of this kind cannot be minimized. The position continued even after the Constitution came into force. It was only in 56, and that's the 22 that your lordships referred to, my Lord Justice Suryakant. Then kindly come to page 19 at the bottom. Placitum H, it is true. 19 words, it is true, as is clear from the 20 Act, that the nucleus of the Aligarh University was the MAO College. Kindly see, Malas, these are all acceptance of our facts.
Where is that? What is the, which is that?
Page, Malas, 19 at the bottom, last paragraph. These are the contradictions in the judgment. It is true that, let me read it. It is true, as is clear from the 20 Act, that the nucleus of the Aligarh University was the MAO College, which was till then a teaching institution under the Allahabad University. The conversion of that college, if we may use that expression, into a university was, however, not by the Muslim minority. What does that mean?
What it says basically is a new institution which has come up.
Naturally, Maharaj, there is no other choice in the matter.
Then we'll see how it was incorporated.
It took place by virtue of the 20 Act, which was passed by the Central Legislative Legislature. There is no Aligarh University existing till the 20 Act was passed. It was brought into existence by the 20 Act. This is the logic. So because it was brought into existence, it loses its minority character.
Now, page 20 at Placid, between A and B, it says it was brought into being by the 1920 Act and must therefore be held to have been established by the central legislature, which by passing the 1920 Act incorporated it.
That's right.
This follows the provisions of the 1920 Act, which said to establish and incorporate.
Correct, absolutely.
That's where they get this.
That's where they get it.
So to that extent, they are right. The 1920 Act said that the Act is establishing and that it is
But
incorporated.
Manoj, it doesn't matter because you can establish and incorporate being a minority institution. It doesn't answer that question, Manoj. Any number of statutes now which do that even today. You are incorporated.
University should be brought into existence.
Who determined?
Who determined? Ultimately, when
The
the
Act.
act,
Yes, that's the question.
legislature,
Of course, the legislature determines the university community, and the conditions are, what are the conditions? That you must have this amount of area, you must have this amount of student teachers, there's be an executive council, there'll be a structure, all that, that's the 1906 conditions. Those are the regulatory conditions. But the choice to set up a university is mine. Now, did the minority set it up or not is the question.
Mr. Sibal, if you come to page 19,
Yeah.
there's one paragraph which is
Yes,
worth reading.
yes,
There was nothing in 1920, the sentence starts like that.
yes, 1920 to prevent the Muslim community, if it so chooses, correct, I'll read it, Mullah, to establish a university. But if it did so, the degrees of such a university were not bound to be recognized. So where does it take us, Mullah? What's the use of having?
Therefore, in order to get the degrees recognized by the government,
I had to.
you had to approach. the
Correct,
government.
Mullah, but that doesn't mean it was established by the government, by the government. That's the question, Mullah. I had no choice in the matter. If I want to be called and to be a university is my right under 30. And the nucleus came from the college and the property and everything. So the question is, I can't be a university. To be a university is my right under 30. That also Basha accepts. This is the problem.
Probably that
Sorry?
even it was not disputed before the bench that even before 1956 Act,
Yes,
the degree could be awarded only by a university,
absolutely.
and that university must be recognized by the government. Then only that degree.
That's right, absolutely. No doubt about it, Mullah. That's
Legal
right.
position.
In other words, Mullah, if my right exists under 30 and I get it incorporated, I lose my right under 30. That's what it comes to.
I think we're just understanding the logic of the court. What they are saying is that a educational institution includes a university. Aligarh Muslim University, in its character as a university, is established by an act of the central legislature. And because it is established by an act of the central legislature, notwithstanding all the efforts which were made by the Muslim community for, sort of in the movement to set up the college and then convert it into the university, the establishment is by an act of the legislature and not by the Muslim
All right,
community.
but let me answer.
That's the logic.
Correct,
which
but
we
let me
find
answer
in
that straight away.
Yes.
The word established in Article 31 is different from the concept of establishment under an act. I answer that straight away. Establishment under an act is the recognition.
This one.
Yes. The word established in 31 has a connotation, 30 sub-article 1 has a connotation which relates to the genesis of the institution, whether it's a college or it's a university or it's a school. Establishment in the statutory sense is the recognition for incorporation to grant a degree. So these are two separate concepts. We can't confuse the word establish in the context of one with established under Article 30, sub-article 1. So there your lordship is right, that in that sense, that word establish is used in the incorporation sense. No, but today, for example, you want to set up a university, you have to go through the same thing. It's a minority university, you go through the same thing, but it doesn't destroy your character as a minority university.
The minorities by themselves do not have the right to create statutorily a university.
Yes.
They have to go to the
You
authority.
have no choice, mother. That's 1906. That's
For that
standard.
matter, any individual doesn't have.
And 30 recognizes your right to found a university also.
That's right. That's accepted even in Basha.
And the only, to establish, yes, to establish a university.
The word
But
established.
the only statutory way of doing it is to
That's
go through an act of
That's
parliament.
right. Then that concept of establishment can't be
That's right.
confused because it's used in two separate senses.
Mr. Sybil, we are on the verge of the stroke of lunch. The bales are about to be removed.
Mother,
I mean,
what happens is
start
sometimes
with
the
your
ball is bowled and the base don't get removed, mother. So therefore, please wait till 2 o'clock. I'll finish very soon.
All right.
Deeply obliged. You're also been very kind.
Yes, Mr.
Mullahs, when we left off, Mullahs, your lordships, I made the distinction between establish. Now, Mullahs, the word establish in Article 30 is used in the constitutional sense. The word establish in the statute is used in the statutory sense.
Just 1 second. Yes, Mr.
This is clear from the definition, and I will read it. University of the UGC Act. University means a university established or incorporated by or under a central act. That's why it's in that sense. The word established in that statutory sense. By or incorporated, established or incorporated by or under the central act. The word established in 30 with reference to the setting up of the institution. And that's where Basha confused the concept of establishment. Even 22 uses the same expression. Same thing. Because you can establish a university by incorporation. That's what it means. Now, let's back to
volume 3A, page 20, Manoj. Yes.
Volume 3A.
Volume 3A, Manoj, page 20.
Yes.
And Manoj, I was referring to that sentence. There was no Aligarh University existing till 20 Act was passed. It was brought into being by the 20 Act and must therefore be held to have been established by the central legislature, which by passing the Act incorporated. The fact that it was based on the MAO College would make no difference to the question of who established it. That's where they went wrong. So he accepts that it was based on the MAO College, but he says it makes no difference. So now let's come straight away to page 21. And that page 21, that's placetum, last paragraph. Yes, last paragraph. Well, let's have that. From the history we have set out above, it will be clear that those who were in charge of the MAO College, the Muslim University Association and the Muslim University Foundation Committee were keen to bring into existence a university at Aligarh. But this is the admission. There was nothing in law then to prevent them from doing so if they so desired without asking the government to help them in the matter. So they accept the fact that yes, we are the ones who wanted to bring a university into existence. It was the minority community. But if they brought into existence a university of their own, degrees of the university are not bound to be recognized by the government. So that's 21. Placetum G. It seems to us that it must have been felt by the persons concerned that it would be of no use bringing into existence a university if the degrees conferred by the said university were not to be recognized by the government. So in fact, Basha sets out the reason why we went. So that's on 21. Now, these are the correct statement of facts in Basha, which I pointed out. Now, the incorrect statements of fact. I'll just point those out. First of all is page 23. The incorrect statements of fact. Paragraph 2 in page 23. Yes. It says, well, it's placetum between B and C, sentence C, it will thus be seen. Your Lordship has that? Paragraph at page 23. Second paragraph, it will thus be seen, just above placetum F, that besides the fact that the members of the court had to be all Muslims, there was nothing in the act to suggest that the administration of the Aligarh University was in Muslim minority as such. Correct?
Where are you reading, Mr. Sibyl?
That's paragraph, page 23.
Yes. Besides, there were other bodies, that para?
Yes, in that para, 5 sentences thereafter, it will thus be seen.
Yes.
It will thus be seen that besides the fact that the members of the court had all to be Muslims, there was nothing in the act to suggest that the administration of the Aligarh University was in Muslim minority as such. Besides the above, we have already referred to section 13, which showed how the rector, namely the Governor General, is overriding powers. This is completely wrong, Malaj, because the overriding power is in every university in the hands of the visitor, whether it is the rector at that time or the visitor now. In every statute, whether it's qua minority, qua majority. The overriding powers are there always, Manoj. But that's not the test. Yeah, Manoj, I'm sorry, my learned friend is right. I missed it out myself. Page 21, end of the page, Manoj, my fault. The hurry, I'm missing out things. Placetum H, Manoj.
Maybe. Maybe accepting.
It may be accepted for the present purposes that MAO College and Muslim University Association and Muslim University Foundation were institutions established by the Muslim minority. Accepts the fact. And the two of them were administered by societies, of course. That's normal. Therefore, 23 is this one fact, which I showed to your lordships. Then kindly come to page 11. I mean, sorry, not page 11. Yeah, page 11. Back to page 11. That's incorrect facts. It says, Mothers, there is no condition. Mothers, placetum between G and F. Last sentence in the second paragraph. There is no condition that the Lord Rector and the members of the visiting board must belong to the Muslim community. Well, how is that relevant? Can it be said that the Governor General of India must belong to the Muslim community? I mean, what? Or for that matter, the Chancellor must belong to that community. In present circumstances, how can anybody say that? There is no condition that the rector and the members of the visiting board must belong to the Muslim community. So that's Mullad's ex facie wrong. Then come to page 13. This again I'm sorry. This again shows. Yes.
At the bottom last, this again shows. Last on the page, 4 lines, this again shows. On page 12, sir, on page 12, right at the.
Yes. Page 12, Malad. You put page 13. That's now what?
Oh, yeah, this. This shows the.
Where is it?
Can we have understood? We have understood.
Yes, now Malad, just see page 13. Placetum A and B. This again shows that in the matter of such disputes, the court, which is called the supreme governing body of the university, did not have the power to resolve it. Whereas if the dispute is between the academic council and the executive council, they say there was no power in the court to resolve it. Well, how does that, what's that? Because arbitration was provided for. How is that relevant for the purposes of establishment?
Okay.
So that, Malad, that's 13. But just one or two more things. Then, Malad, kindly come to page 13 at the bottom. There is nothing anywhere in any section of the Act. Where is it?
Second line.
Yeah. There is nothing, Malad, last paragraph, second line, there is nothing anywhere in any section of the Act which vests the administration of the university in the Muslim community. The fact that in the proviso of 223 it is provided that the court of the shall consist only of Muslims does not necessarily mean that. Now, Malad, this is factually incorrect, and your lordships may note that. In the academic council, 15 members from the court are from the court, which are Muslims. Factually incorrect statement. Page 19. Volume, your lordship may just note that, page 19, volume 3. In the EC, 20 out of 30 are elected by the court.
Just give us the date, figures again.
Yes. In the academic council, 15 members are from the court and are all Muslims. That's at page, because at that time court were all Muslims. That's page 19, volume 3G. And that's the academic council. In the executive council, 20 out of 30 were to be elected from the court, all Muslims. That's 2/3. And 6 were to be elected by the academic council, which were also Muslims. and VC and PVC were to be elected from the court. They were also Muslims. So for him to say that there is nothing anywhere in the section which vests the administration, is so factually so incorrect from the act itself. It's not outside the act. One is at page 19, the second is at page 21, and the third is at page 11, page 11. The AC is at page 19, EC is at page 21, and the control is at page 11. Control was of the minority community. So that is factually incorrect. The next one, the next one, page 18, Malas, right at the top. We have to examine closely what happened. We have already so therefore forget that, Malas. I've already said that. Then page 19, Malas, second paragraph. There is nothing in the 20 Act to prevent the Muslim majority, if it's so minority, to establish a university. But if it did so, the degrees of were not bound to be recognized. Already said that. And then, Malas, he said, it may be that page 20, that the 20 Act was passed as a result of the efforts of the Muslim minority. But that does not mean that the Aligarh Muslim University came into being. That's it. It's page 20 itself, Malas. It's contradictory. Page 20, placetum D, Malas. Yes. It may be that the 20 Act was passed as a result of efforts, but that does not mean. So that takes care of that. Then page 22, placetum E, C. It was thus, that's one. It was thus the central legislature, placetum C, which brought into existence the Aligarh Muslim and must be held to have established it. That's the basis of the order in any case. Then right at the end, last paragraph, it appears from paragraph 8 of the schedule that even though the members of the court had to be Muslim, the electors were not exclusively Muslim. That's neither here nor there. I've already shown that, Your Lordships. Then page 23, first paragraph, last 3 lines. Further, 15 members of the court were to be elected by the Academic Council, the membership which was not confined only to Muslims. Sure. Then page 23, these provisions in our opinion, placetum, placetum between F and G. These provisions in our opinion clearly show that the administration are not relevant, really speaking. We are on administration. So really that takes care, Malas, of what was right and what was wrong. So Malas, I've done that. And the last thing now, then I've done it. What is the last thing? What is it that we brought in and what was transferred to Aligarh Muslim University? 1, 30 lakhs.
Just one second.
Yes, government at that time asked us to bring this in. 30 lakhs raised by the Muslim University Association, which is worth 300 crores today. In 2005, it was valued at 287 crores. This is reflected in Section 7 of the 20 Act. Section 7 of the 20 Act, Volume 3G, at page 7. Section 7 of the 20 Act, Volume 3G, at page 7. So founded. That's what Dr. Dhawan Malas kept on saying. It was founded. So the sponsorship is ours. We sponsored it. All land, infrastructure, movable, immovable properties of MAO College and the Muslim University Association stood transferred to AMU. So all land, all infrastructure, movable, immovable properties of the MAO College and the Muslim University Association stood transferred to AMU. So all the assets, movable, immovable, all transferred. That's at section 4.1 of the 20 Act in volume 3G at page 6. Section 4.1 of the 20 Act, volume 3G, page 6. The next is even more important. Any property given to the MAO College or Muslim Association by gift, trust, would be read as will gift to MOU. Kindly see, this is a private, your Lordship knows. A will is a private act, and a private instrument. Even that, is deemed under the Act to be given to be a gift. Even government land becomes theirs, This shows continuity, This is section 4, small Roman 4 of the 1920 Act. Section 4, small Roman 4 of the 1920 Act, volume 3G, page 6. Then, all buildings of MAO College. Next, all buildings of MAO College were to vest in the AMU. And the same name were to be kept of those buildings. Main names could not be changed. That's, section 4, Roman small 5 of the 20 Act.
Section 4.
Small Roman 5 of the 20 Act, volume 3G, page 6. Then, 5. All employees of MAO College transferred to AMU. Yes, shows continuity, all this shows. This is, volume 4, Roman small 6 of the 20th Act, volume 3G, page 6. All employees and all students of the MAO College permitted to complete their education in the AMU. So students were transferred, again, continuity. That's section 32, brackets 5 of the 1920 Act at page 14. So this is how, the continuity is established, the genesis is established, the foundation is established, and Basha acknowledges all this, but it says doesn't matter because there's an act. It matters. Matters because this is the only institution of its kind set up with intent to serve the interests of secular India and to protect the minority institutions in empowering their children and others to be part of the workforce of India. If you reject this, you destroy that dream. That dream should not be destroyed. Thank you very much.
Thank you, Mr. Appellant. Yes, Mr. Khurshid?
The Lordship may pardon me for a while.
Yes.
Is there any other note? Okay. Things in like
Well, please, Your Lordship. Lords, I adopt whatever my learned colleagues have said, Lords, with appreciation and gratitude. I'm only picking out some first principles, Lords, that would, I believe, assist Your Lordships in coming to a conclusion, which essentially, as I understand, is simply in the backdrop of whatever has been explained to Your Lordships, whether the establishment word used in Article 30 leads to a situation in which everything is there except the actual act of establishing it by an act of Parliament. Does that take away? So, my Lords, essentially, there are three propositions that I'm placing before Your Lordships. My Lords, very, very briefly, in a few minutes, the backdrop of Aligarh Muslim University. My Lords, the Lordships have been told how Sir Syed Ahmad pursued the establishment first of an MAO college and then his followers pursued the establishment of the university. Well, the matter begins with 1957, and the Sir Syed wrote out this great book, the treatise about the reasons for the uprising, the mutiny, or what we call independence, the war of independence, the first war of independence. And thereafter, one of the important causes for him, as he found, was the backwardness of Muslim community, particularly the educational backwardness of the Muslim community. So he set out to bring about education. He had already set up something called the Scientific Society, the purpose of which was to translate scientific books into Urdu so that they could be made accessible to the community and make the community more aware of what the scientific developments were happening. And that was Sir Syed. He then, my lords, after 1857, he visited Oxford University. He tried to absorb and understand how a good university could be made. And then, of course, the same designs of Oxford University were reproduced in the architectural plans of what was MAO College and then Aligarh University. Of course, we didn't have colleges as Oxford and Cambridge have, but the buildings were designed around what are called halls of residence. It was to be a residential university, so there were halls of residence, each hall having very eminent background and each hall having a particular character. So, my lords, there is what is called in Aligarh an Aligarh Tehzeeb. It's very important. And I'm saying all this, my lords, because I have a sentimental attachment to Aligarh. I was born in the Vice Chancellor's house, and therefore I do have a claim sentimentally on Aligarh. But be that as it may, my lords, there's a particular Tehzeeb translates into culture or a subculture that Aligarh represents. I do believe there's a culture in every great institution. Lordships know culture in every great institution, but Aligarh has a unique culture, which a great deal has to do with ability to speak, ability to propound, ability to interact, ability to imagine, and to project. My lords, this is seen right through the Aligarh University's culture. My lords, so when the university is established, your lordships have also already seen that it was established with the effort of the community. And therefore, I distinguish in first principle two kinds of establishments, well, two kinds of statutory acts that may be propounded by government. One is a non-consensual act, where, my lords, an institution that has fallen on bad times, where there is widespread talk of corruption, that people are not being served as they should be served. And the government steps in to say that in order to save this institution, we need to take it over. And they take over that institution. It's a non-consensual necessarily. But there can also be a consensual takeover, which is exactly what Aligarh was about, where everybody gathered and said, please convert us into a university. And as Mr. Kapil Sibal just argued, all those assets and the entitlements of MAO College were handed over to the university. Malad, two things have happened. When Aligarh Muslim University Act was passed in 1920, it was not assumed that there would be a difference between two different kinds of universities, which we now have become familiar with, private university and a public university. Your lordships asked what minority institutions or university level institutions are there. And it seems that Aligarh being one, provided your lordships agree with us, Jamia University is the second one, dependent on whatever the decision will happen in Aligarh. Jamia was a breakaway offshoot of Aligarh. Jamia was part of the independence movement because in the independence movement, it was felt that whatever
Khurshid, we're not dealing with Jamia's case because that's a separate matter. So if you want to go into that, maybe expanding the scope of the reference.
Well, I'm only saying that your lordships asked me if there were more than Aligarh institutions that were likely or felt to be minority institutions. Jamia is one, but that's also in litigation, and I do believe in the High Court.
From Jamia, any other examples in the country?
Well, the other there are other examples. In fact, the other side has produced some examples. Those are all so-called private universities. Well, there's the Mahavir Jain University. There is the Christ University. Christ College, your lordships mentioned Vellore Medical College. Now, my lords, what has happened there is most of the Christian institutions either are like St. Stephen's College within a larger complex of a university, or they are all deemed universities. So, my lords, if you start with a school, you start with possibly a society that is registered under the Registration Act. From the society, you develop a college that is also under Registration Act and whatever affiliation is provided. The college then could possibly become deemed university. Nothing happens. The character is preserved throughout. It's just the transformation from a deemed university to a full university when the question marks come. Your lordships asked about Jamia. Jamia retained that character without any question while it was a deemed university. The moment Jamia became a full university, Jamia also came under the same question mark that now is placed before Aligarh University. So, my lords, the private universities are there, but just for your lordship's information, the private universities that are treated as minority institutions has a slight tweaking from the model of Aligarh. Well, Aligarh model was that everything that was owned by the societies was handed over. Jamia did the same thing, was handed over to the university, and the societies were dissolved. What the private universities now are doing is that the society doesn't get dissolved. The society retains whatever it has, but the society comes under the umbrella of a university, and the society is told the conditions, once they are met, the government should be informed that the conditions are met, and on meeting those conditions, the university will come into operation. So today, the dichotomy is that you can have a private university, provided your lordships at some stage in this matter or elsewhere hold that just the fact that the university has been established in inverted commas by an act of parliament or an act of the state legislature will not deny it its minority character. That finding hasn't yet come. But if there is such a finding, then private universities would exist. But as far as we understand, from our point of view, if your lordships decide against us and in favor of Aziz Basha, as decided by the bench of 5 judges, then we couldn't, one way or the other, get a private university or a public university that would have the tag of being a minority university. So that's very critical. And well, for this purpose, what I'm asking your lordships to do is to consider that when a society is registered, you can get together and could be a group of people, unorganized people, etc., can set up a school. But in order to get legal identity or legal entity or legal personality, they have to register themselves as a society. And the registration is under a statute. The registration is an act, the lowercase act ACT of the government or of the state, and yet it continues to be recognized as a private university. Here, the moment you go beyond a deemed university and you ask for being made into a full university, your lordships have already heard it can only be done through an act of parliament, and therefore the moment it's done through by act of parliament, you lose your. So you're giving by one hand under Article 31 and taking back by the other hand by saying, well, if you're constituted or you are established or you're formed. So if your lordships were to use the meaning of founded, it would be easy to then come to a conclusion that founding involves a participatory inclusion of the sponsoring society. In the private universities, they are now called sponsoring societies, whereas here your lordships saw the history. My lords, my second point would be a brief point.
Yes.
As your lordships have noted, and the Aziz Basha judgment has also noted, MAO College was a minority institution. There is no doubt about it, and your lordships have been shown all the indicia for something being a minority institution. Well, lords, just a brief point related to this. The actual administration could well be part of the indicia to decide whether it's a minority institution. But it may well be that an institution that is to be administered after it's come into the status of a university may have an extent of regulation by which the administration, the free administration may be restricted to some extent. That will only be enabling provisions restricted by in terms of reasonable restrictions. But that may not have any reflection on whether it is a minority character or not. If it is a minority character, the restriction will be limited. If it is not a minority character, maybe the restriction will be more liberal. But my lords, TMA Pi has indicated that where there is an unaided minority institution and an unaided private university, private institution, which may not be a minority institution, the difference in the extent to which you can regulate is very limited, Maximum freedom must be allowed to educational institutions. And what the maximum freedom that is needed for a minority institution is to carry the flavor of the minority institution, the culture and ethos of the minority institution. My lords, that is very, very critical. Then, my lords, if your lordships will turn just briefly to my written submissions, because your lordships will see it in 1B. I must apologize, my lord. There is an article that, because of some technical difficulties, attached to this. It's an article which only indicates the request that your lordships look at this matter in a particular manner in which Ronald Dworkin has described it. So, my lords, your lordship will see in the backdrop of what I told your lordships about Aligarh, your lordship will just see there the second paragraph. It's very important, historically very important. Your lordships will find this in Mr. Noorani's book, which is in volume 3H. This is taken from Mr. Noorani's book. Your lordship will see the second paragraph. The way Aligarh participates in the various walks of national life will determine the place of Muslims in India's national life. The way India conducts itself towards Aligarh will determine largely, yes, that will determine largely the form which our national life will acquire in the future. Well, this is a statement made at a stage when Dr. Zakir Hussain was Vice Chancellor. And having said this in the presence of the President, Dr. Rajendra Prasad, who was visiting the university. Well, it was Aligarh University from the time of Prime Minister Nehru to the time of Prime Minister Modi has a rich legacy of how the top leadership of the country has seen Aligarh. Time of Nehru, Nehru came and asked whether Aligarh didn't have a tarana. It didn't have a song of the institution. And promptly, that very night, a student inspired by what Prime Minister Nehru had said, his name being Majaz Lakhnavi, he grew up to be an outstanding poet of this country. Majaz Lakhnavi, then a student, alumnus of the university, sat down that night and wrote out the tarana. Well, if your lordship will permit me just 4 lines of that tarana, just to give you a flavor of how the community and those who participated in education at the university actually saw that university. Just 5 lines, Baloj. I'll translate any word that might be different. Ye mera chaman, ye mera chaman, ye mera chaman hai, mera chaman, apne chaman ka bulbul hum. I am the nightingale of my garden. This is my garden. This is a chaman that I belong to. Jo tare haram mein roshan hai, wo shamma yahan bhi jalti hai. The light that you find in the Haram Sharif in Medina is lit here as well in this university. Is dash ke goshe goshe se ek juए hayat ubalti hai. From every spot in this garden, there is a stream that flows, and that stream is the stream of life. Ye dashte juno diwano ka, ye bazme wafa parwano ki. This is a place of passion of those who are passionate about what Aligarh is. And this is also the place from where we rise like a parwana. We rise and fly high up in the heavens. Ye shehri tarab rumano ka, ye khulde bari armano ka, essentially, basically, this is the citadel of those who have aspirations and those who have dreams. Fitrat ne sikhaya hai humko. Nature has taught us here कि उफ्ताद यहाँ, परवाज यहाँ, begin your life, learn to begin your life here, learn to fly high from here. गाए हैं वफा के गीत यहाँ, we have sung the songs of faith here, छेड़े हैं जुनू के साज यहाँ. This is where we have started the lyrics of wafa, of faith. So, my lords, this is the flavor. This is the flavor caught by Majaz, but this is the flavor that all of the Muslim community felt about Aligarh. And there were resistance for Sir Syed from people who were extreme conservatives. And my lords, we are talking about pre-partition days, extreme conservatives who resisted this. And when Sir Syed went out to collect money, they said, we will give you money, but first show us that you can dance like the British. You want to make a university that is universal. You want to make a university that can compete with Oxford. You want to make a university that is of high intellect, etc. Well, why don't you first show that you can dance like them? And he bore this with fortitude. He bore this and said, whatever money you give, I need it for my university. I'll take it for my university. And that was the great sacrifice that he did. So then the next proposition I have is, how would your lordships, as your lordships are examining essentially fundamental rights, your lordships are looking at part 3, a fundamental right that the minority has been granted for setting up institutions. Whether that fundamental right can be cut down or not cut down by an interpretation, my lords, is what I am asking your lordships to consider. And in this, my lords, your lordship be good enough to turn to volume 5, 5C. A judgment. Well, it's 5B. Your lordship will turn to 5B at page 366. Paragraph 42, my lords, there are just 3 or 4 paragraphs that I will indicate to your lordships. My Lord Chief Justice's very eloquent description of the nature of fundamental rights. Because I want to pinpoint this because this would help your lordships then take a view on what to be done with the Article 30. Because if your lordship will just allow me to read a little bit, because obviously in the context of privacy, the page is 366, paragraph is 42 in 5C.
Yes.
Well, your lordships have started with privacy because that was the issue before your lordships, the privacy as a fundamental right. Your lordships have considered John Locke, and your lordships have considered William Blackstone, etc., etc. And in paragraph 43, your lordships have summed it up. The notion that certain rights are inalienable was embodied in the American Declaration of Independence in the following terms. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that amongst these are life, liberty, and the pursuit of happiness. The Lord's life, as interpreted in Article 21, your Lordship knows, goes far beyond the original text of the Constitution. Then, my Lords, your Lordship will be good enough to come to the bottom of 43 at page 367. In quotes, my Lords, right at the top of that page, for its drafters to ignore, to forget, or to depreciate the rights of man are the sole causes of public misfortune and government corruption. These rights are natural rights, inalienable and sacred. The National Assembly recognizes and proclaims them. It does not grant them, concede or establish them. It was an interesting word, establish, used here. And their conservation is the reason for all political communities within these rights figures resistance to oppression. And then, my Lords, Roscoe Pound in paragraph 44, the spirit of the common law, the quote is, natural rights means simply interests which we think ought to be secured, demands which human beings may make, which we think ought to be satisfied. It is perfectly true that neither law nor state creates them, but it is fatal to all sound thinking to treat them as legal conceptions. For legal rights, the devices which law employs to secure such of these interests as it is expedient to recognize are the work of the law, and in that sense, the work of the state. Then, your lordships will see the next quote, which is on the classical natural law that's found in the revival of natural law. Second line, one was natural rights, qualities of the ideal or perfect man in the state of perfection, by virtue of which he ought to have certain things to be able to do certain things. These were a guarantee of stability because the natural rights were taken to be immutable and inalienable. Please, Lords. The social compact, a postulated contract basis of civil society, here was a guide to change, an ideal law of which positive laws were only declaratory, an ideal body of perfect precepts governing human relations and ordering human conduct, guaranteeing the natural rights and expressing the social compacts. Well, it's the social compact of equality. It's the social contract of participation. And so social contract, as your lordships have seen, of life with dignity. And would your lordship then consider that the entire range of rights, certainly the rights of life with liberty, includes the right to educate yourself, includes the right to educate yourself with other colleagues and with other friends, and that rights should not be truncated by an interpretation of court saying this established. And there, my lords, your lordships already have what Mr. Kapil Sibal had argued. My lords, then 46, because this sums up paragraph 46 at page 368. Natural rights are not bestowed by the state. They inhere in human beings because they are human. They exist equally in the individual, irrespective of class or strata, gender or orientation. So, my lords, this really sums up. Then, if your lordships will quickly look at paragraph 48, and there I believe, my lords, because this will link up with the article I wanted to place before your lordships, the idea that individuals can have rights against the state that are prior to rights created by explicit legislation has been developed as part of a liberal theory of law propounded by Ronald Dworkin in his seminal work titled Taking Rights Seriously. In my lords, next page, 369. Your lordship will then see page 369 at the bottom. This is Ronald Dworkin. Individual rights are political trumps held by individuals. Individuals have rights when, for some reason, a collective goal is not sufficient justification for denying them what they wish as individuals to have or to do, or not a sufficient justification for imposing some loss or injury upon them. Dworkin asserts the existence of a right against government as essential to protecting the dignity of the individual. It makes sense to say that a man has a fundamental right against the government in the strong sense like free speech, if that right is necessary to protect his dignity or his standing as equally entitled to concern and respect, or some other personal value of life consequence. And my lords, that I believe is what your lordships are now looking at in terms of the rights of the minority. Then, my lords, if your lordships will come to one more important 419, if your lordship will come to 419. Lords, that's important because it indicates how your lordships have handled the issue of rights. 419. Well, lords, just before 419, if your lordship will come to page 408, And this is the beginning of Your Lordship's discussion on fundamental rights, paragraph 120. Just above paragraph 121, I'll save Your Lordship's time in reading everything. Well, the last 3-4 lines, the fundamental rights, in other words, are primordial rights, which have traditionally been regarded as natural rights. In that character, these rights are inseparable from human existence. They have been preserved by the Constitution, this being a recognition of their existence even prior to the constitutional document. So, Mullahs, I would argue that these rights that minorities have as individuals existed before 1950. And if in the 1950 translation of those rights into the document would in any way truncate them, then Your Lordships would consider whether there are possible ways in which that truncation can be avoided. And in this case, it is only a matter of interpretation. It is not a matter of voiding any portion or rewriting that portion, but merely a matter of interpretation given by 5 eminent judges of this court to see if that interpretation could itself be altered to give more meaning to natural rights and to human rights. Well, Lords, 418 is where Your Lordships come to, having considered all the general fundamental right cases, Your Lordships come to what Your Lordships call discordant notes. Well, it's in the entire thesis that Dawkins has, Dawkins' thesis of how to look at institutional interpretation of rights. He also has a significant section which talks about the mistake, a mistake that must be corrected, a mistake that must be restricted at an appropriate stage. And here Your Lordships are considering ADM Jabalpur as a possible mistake. And then if there is a mistake, what is best to be done? Your Lordships considered what the majority had said. Then at page 144, Your Lordships come to the dissenting opinion of my Lord Justice Khanna. This is page 418. In his dissenting opinion, Justice Khanna emphatically held that the suppression of the right to move any court for the enforcement of the right under Article 21 upon a proclamation of emergency would not affect the enforcement of the basic right to life and liberty. The Constitution was not the sole repository of the right to life and liberty. ADM Jabalpur goes on even to say so. Then, my lords, Your Lordship will just leave that paragraph 525, internal paragraph 525, and Your Lordship's comment then comes at the bottom of that paragraph. Even in the absence of Article 21, it would not be permissible for the state to deprive a person of his life and liberty without the authority of the law. Your Lordships are actually saying that even in the absence of 21, because of whatever legislation or whatever the law that is being propounded, it will not take away your right to come to court to seek remedy. That was the critical decision in dissenting judgment that my Lord Justice Khanna gave. Then, my lords, at page 136, very quickly, at page 419, paragraph 136, Your Lordships held as follows. The judgments rendered by all the 4 judges constituting the majority of ADM Jabalpur was seriously flawed. Life and personal liberty are inalienable to human existence. These rights are, as recognized in Keshav and Bharati, primordial rights. They constitute rights under natural law. The human element in the life of the individual is integrally founded on the sanctity of life. Dignity is associated with liberty and freedom. No civilized state can contemplate an encroachment upon life and personal liberty without the authority of law. Neither life nor liberty are bounties conferred by the state, nor does the Constitution create these rights. The right to life has existed even before the advent of the Constitution. In recognizing the right, the Constitution does not become the sole repository of the right. It would be preposterous to suggest that a democratic Constitution without a Bill of Rights would have individuals governed by the state without either the existence of the right to live or the means of enforcement of that right. the right to life being inalienable to every individual. It existed prior to the Constitution and continued in force under Article 372 of the Constitution. Justice Khanna was clearly right in holding that the recognition of the right to life and personal liberty under the Constitution does not denude the existence of that right. Apart from it, nor can there be a fatuous assumption that in adopting the Constitution, the people of India surrendered the most precious aspect of human persona, namely life, liberty, and freedom to the state, on whose mercy these rights would depend. Such a construct is contrary to the basic foundation of rule of law, which imposes restraints upon powers vested in the modern state when it deals with liberties of the individual. The power of the court to issue a writ of habeas corpus is a precious and undeniable feature of rule of law. And your lordships can consider various other judgments, and your lordship then finally overruled the majority as far as the habeas corpus case was concerned. Well, I'm asking your lordships to consider whether the same perception would apply to interpreting the Constitution. I'm not asking that any part of the Constitution be held void. That would be a very far-fetched argument. But the integrity of the Constitution and the harmony of the Constitution in the sense of how it tries to represent primordial rights, my lords, would lead your lordships, I hope, to actually coming to a conclusion that the word established when it comes to minority rights of education is something that had to be considered liberally to include participatory functioning. Only the de jure regulation may come from the statute because it cannot come in our system from anywhere else. But that the purpose of the statute and the heart of that statute and the background history of that statute, of the act itself, would have to be considered. Well, lords, then this is the fundamental argument that I'm placing before your lordship. But if your lordship would now consider going back to my written submissions, well, lords, there is in what I'm saying is supported by the thesis that Donald Dworkin places in his book called Freedom's Law, but it's reproduced here as it first appeared, the moral reading of the Constitution. If your lordship will see, this is at page 9 of my written submissions. Volume 1B. Right at the top, my lords, is, my lords, I'm emphasizing this because several of your lordships have in many judgments have indicated how Dworkin can influence decision-making in terms of how two conflicting views have to be harmonized and how the judge has to come to a conclusion. If I may just read that little bit here, my lords, in paragraph 1. There is a particular way of reading and enforcing a political constitution, which I call the moral reading. Most contemporary constitutions declare individual rights against the government in a very broad and abstract language, like the First Amendment of the United States Constitution, which provides that the Congress shall make no law abridging the freedom of speech. The moral reading proposes that we all, judges, lawyers, citizens, interpret and apply these abstract clauses on the understanding when they invoke moral principles about political decency and justice. The First Amendment, for example, recognizes a moral principle that it is wrong for government to censor or control what individual citizens say or publish, and incorporates it into American law. So when some novel or controversial constitutional issue arises about whether, for instance, the First Amendment permits laws against pornography, people who form an opinion must decide how an abstract and moral principle is best understood. They must decide whether the true ground of the moral principle that condemns censorship in the form in which this principle has been incorporated into American law extends to the case of pornography. Then, my lords, next paragraph, the moral reading therefore brings political morality into the heart of the constitutional law. But political morality is inherently uncertain, etc., etc. Well, lords, then this article goes on to what are the alternatives to this moral view. I would argue, my lords, that this moral view that Dworkin has suggested is already reflected each time your lordships have said that there is a constitutional morality that we must submit to. initially known by way of constitutional values, but your lordships have now talked about constitutional morality. The political morality that Dworkin talks about is similar to constitutional morality that your lordships have applied. And constitutional morality looks at the constitution as a whole, not in pieces, etc., to arrive at an integrated idea. And I submit, my lords, that an integrated idea of constitutional morality would certainly point your lordships towards coming to a conclusion that minority rights can't suddenly disappear by way of an artificially restricted interpretation of a word like established. Well, that's basically my argument to essentially support what all the other council have argued, that this is an additional reason, the moral reading of the Constitution that would give your lordships this conclusion. I'm deeply grateful, my lordship.
Yes, Mr. Farah, sir.
As I am appearing in Civil Appeal 2316 of 2006, that's 701.7 before your lordships board. Because your lordships in this 7-judge combination are being essentially called upon to interpret the word established in Article 30 of the Constitution, and whether the meaning of established as given by Aziz Basha is correct. Because if I have understood the purpose, the core purpose of the reference. Well, I'll begin my submissions by borrowing from my Lord the Chief Justice's observation today. Well, how do we read Article 30? Do we read as something which creates a ghetto? Or is it for a larger purpose? Because my respectful submission, and I'll just flag two submissions are there, but just as an opening, I'll flag is that in any country, a minority craves for two things, which Article 30 recognizes. And those two things are firstly, to retain its minority identity. And secondly, while retaining its minority identity, to fully and completely participate in the national life and national mainstream. Plus, in my respectful submission, Aziz Basha, apart from the specific reasoning, proceeds on the basis that you can do either one or the other. You can't do simultaneously both. So you can be a minority, you stay in your space, but if you become a university and the law requires you to, the parliament to enact something, then you lose your status. You can't be both. If you have provisions in your statute which permit others to be part apart from the community for which it is being established, that may disentitle you. Plus, that's the background. Plus, the second background submission is that your lordships will bear in mind that AMU, today we are testing AMU status in 2024. In its present form, it has existed from 1920. 104 years. Even if we exclude the MAO portion. And then if we include that, it's 150 years. Plus, AMU is one of the main factors, if not the main factor, for creation of an educated Muslim middle class in India. It is responsible for it, and it continues to nurture it. If your lordships were to come to a conclusion that it's not a minority institution, my respectful submission would be that would gravely damage that role which AMU has played. Plus, with that background, my two submissions I'll just flag and then I'll go into them. Plus, the first submission is that the distinction between establishing an education institution and the device to bring it into legal existence is well recognized in our law, which has been completely ignored by Basha.
Distinction between
establishing an educational institution and the device to bring it into legal existence is well recognized in our law, which has been completely ignored by Basha. Well, that's my first submission, my lord, which I'll seek to develop. Plus, any educational institution, forget a university, my lord, that your lordships have clearly seen, requires a statute. Any educational institution will necessarily require a legal device. A college, a constituent college may require something else, affiliated college may require something else, a school you will require a registration. Plus, the logic of Basha is, and lordship saw that when Mr. Sibal was arguing, that was shown to the court, that the central legislature established the minority institution because the statute was passed by the central legislature, the imperial legislature. Established, and that's the meaning of established for the purpose of Article 30 of the Constitution. Because my respectful submission is, it conflates, obviously, establishment and incorporation. That it definitely conflates. But what it also conflates is established by and established through. It is established by a minority through the legal device of a statute. And this distinction is actually the fulcrum on which all private universities exist in our present day legal regime. I'll show that. Your lordships will just have volume 3I. I just want to show the distinction between established by and established through. Volume 3I, my lords, will have.
Volume 3.
I for India, my lords. Page 3 of that. Well, this is a UGC regulation. It's called UGC Establishment of and Maintenance of Standards in Private Universities Regulation 2003. It begins at page 2, my lords, of volume 3I. I am referring to, my lords, the definition of a private university at page 3, 2.1. Private, my lords have that, all my lords have. Private university means university duly established through a state/central act by a sponsoring body with a society registered under the Societies Registration Act 1860. The law, the statute is the device. The establishing authority is the registered society, in this case a sponsoring body. Well, that's the fundamental distinction in my respectful submission which Basha misses. A statute can be a legal device, well as the highest form of legal device, undoubtedly. There can be lower forms of legal device. A registration certificate under a Society's Registration Act. That is also issued by a governmental authority. By the logic of Basha, that is also established by the government. Now, my lords will have just volume 3H. Just the private university regime is based on a sponsoring body. Normally, my lord, it's a business house or it could be a charitable organization which establishes a registered society. They prepare a plan, they put it to the government of the day. The government either enacts an act bringing that university into existence, separate act, or there are states which have a regular one act and you add it as a schedule. So as you come along, you add one university after another as a schedule. Now, in that respect, my lords will have volume 3H.
What about 3.1?
My lords. That's right, my lords.
Shall be established by a separate state act. Here, the preposition used is by.
That's right.
Whereas in the definition, it is through.
Plus that,
what is the effect?
Well, the point really is that when established, your lordship say right, it uses by. But I'm trying to emphasize the larger principle that the legal instrument is only a device. Well, obviously, let us, well, if Basha is right, let's test the proposition. Under Article 30, we are interpreting the word establish. Every establishment will be by some legal action. Minorities can never establish anything, forget a university. Because it will be any, even if a college is there, it will be a registered society. The registration will be issued by a authority, established by that central government authority, registrar of societies. Instead of parliament, central, this is imperial, the finding is, it's the imperial legislature, instead of that will be established by registrar of societies.
No, but don't you think that
That's exactly, I'm so grateful to my lords. I'm just coming to that. Because in fact, the private university regime also has minority institutions within it. And my lords, 5 of those institutions are relied on by learned solicitors in his written submission. I'll refer to them. And all of them, in fact, support our point. So, my lords, with that, just come for a moment the UP Act. And that is in volume 3H. Kindly have volume 3H. Page 231 is where it begins. Kindly have page 234. 3H.
PH 234.
At 236, kindly have the definition of sponsoring body, AA. A sponsoring body in relation to a university established under this act means a society registered under the Societies Act or any public trust registered under the Indian Trust Act. Very similar, AMU was effectively run by a registered society, and Mr. Khurshid pointed out. Now, of course, there was those societies subsumed. Now it continues to exist separately, but it is established by the society through the device of the act.
Which is the provision you're referring to?
It's 2AA.
AA, yes.
At page 236. A sponsoring body in relation to a university established under this act. And MANOJ bill has section 8. Which is at 242. But I am only arguing for the broad principle. I am not. Your Lordships will have 8. On the commencement of this act, the existing universities enumerated in Schedule 1 shall stand incorporated under this act. So, you can have something existing. A legal device incorporates it. Now, just have the schedule, my lords, at 261. Plus 261, there's a schedule. Above the schedule, it says 63. Notwithstanding anything contained in this act, the university established by a religious or linguistic minority of the state of UP shall continue to have the privileges as guaranteed under Article 30. Well, this provision, in my respectful submission, is meaningless if Basha stands. Because Basha says the minute a legislation intervenes, you lose your status. So, Manoj, this provision obviously cannot, just like the High Court in the impugned judgment here has said, a parliamentary amendment cannot set aside the basis of Pasha, which is interpreting established under Article 30. Neither can this provision. Now, my lords, will just have the first, the Integral University Act. Well, these are examples which the learned solicitor only has given. I'll just come to his written submission. The Integral University Act, it's a minority institution. Serial number 5, Tirthankar Mahavir is a Jain University, also a minority institution. And my lords, over the page at serial number 27, Era University, Lucknow. That is also a minority institution. So the correcting means era.
What is
Era.
Era.
Era University, Lucknow. Now, my lords, will have the learned solicitor's written submission, volume 2B, page 51. Para 85.
Volume 2.
B for Bombay.
Page
51, my lords, para 85. My lords have that. Para 85. An analysis of legislations establishing other minority universities makes it clear that where the intention was to establish a minority institution, the legislature had included specific provisions in the Establishing Act itself to give the university a character of minority institution. Well, the first example is Sam Higginbotham University of Agriculture, UP. It says, well, at the bottom, that established and administered by the ecumenical minority Christian society, namely the Sam Higginbotham. Well, my respectful submission is, this is exactly what the amendment in 81 sought to do in the case of AMU. Plus the 81 amendment which your lordships read yesterday, the definition of university that was established by the Muslim community. The 81 amendment is exactly this.
But his argument is not that. His argument is at the stage of establishment itself.
But that makes no difference for the reason. I quite see what the question is.
That's not his argument.
Well, but that makes no difference. No, I'm not putting an argument in,
as it is.
No. So, my lords, established and administered by the ecumenical minority. The proposition I'm placing for my lord's consideration is this. It makes no difference how the parliament or a legislature describes in the statute as to the formation.
There may be a flaw. Logically, there is a flaw. The flaw is because Article 30 uses the word established and administration.
Correct.
So you can't by a legislature, even if it is not established, create it, because then there will be conflict between the legislature and, in fact, you're countering your own.
No, I'm making the same. If I've understood my Lord Justice Khanna's question.
Argument now.
No, if I've understood my Lord Justice Khanna's question.
Yes.
My Lord,
First, you raise the point that the statute cannot take away my right, which is under the Constitution, which is the right given to under the Constitution is to establish a minority university or an institution. The statute cannot take away that right. But now you're arguing to the contrary, where the statute itself provides for it.
Well, I am saying the statutory amendment, be it in the case of AMU or be it in the case of this university, makes no difference till the time the authority in Bhasha stands, which is that the minute you legislate, you lose the status. So these universities all have to go too. It makes no difference that they describe it. That's the point I'm making. In support of these universities, the learned solicitor is saying that, listen, they say that it is established by the minority. But that's not the test in Bhasha. Bhasha says the minute a legislature intervenes, out you go. So everything goes. But I swim and sink with the examples the learned solicitor has given to support his case and against me. So the point I'm making.
So according to what the 1981 Act did was
Yes.
recognize this dichotomy. The 1981 Act recognized that the establishment of the educational institution was by the Muslim minority. The legal form which was given to it of incorporation was brought about by the 1920 Act.
Correct. So all I'm saying is that explanation really.
And by essentially what the 1981 Act has done is to recognize that as a matter of fact, the establishment was by the Muslim minority, though as a matter of fact, the form of giving it a legal device in the form of an incorporation was brought about by a statute.
That's correct. But the problem still remains, and that's why the High Court has struck it down. Your Lordships will have page 54. What's the basis on which the High Court strikes down that first university definition? Only on the basis that Bhasha means under the Constitution, established, Article 30, established is equal to incorporation. Since you have a statute, therefore in the statute, what the Parliament says is irrelevant, therefore it has to go.
So to the extent that Bhasha equated establishment with incorporation,
Yes.
it was open to Parliament to adopt a varied approach by distinguishing the constitutional facet of establishment
Yes.
from the legal device of giving that establishment a legal recognition.
And that could have possibly been done only through a constitutional amendment. That's the short. So what I'm saying.
A legislative amendment.
Constitutional amendment. You would have had to amend Article 30 itself because you are changing the interpretation of 30 as interpreted by Bhasha. So the only thing the Parliament could have done is amend Article 30 itself, which it didn't do, and therefore it has been struck down here by the High Court. That's why your Lordships are reconsidering judicially now whether Bhasha is correct. That's the short point for your Lordships. So my submission is this: if
We have
Basha,
understood. We have understood.
yes, so that's the first submission. So if Basha stands, then if there cannot be a minority university in this country, forget VMU, including the examples the learned solicitor has given. All of them will go. They have to go. If Basha stands, all of them have to go. I will go, but so will they. Because the second submission as a subpart of that is, because Article 30 interpretation cannot be hinged on the changing regulatory landscape of educational universities or institutions. Well, I'll just give an example. The East India, before there was no Companies Act. As you Lordship knows, the East India Act, company was established under a specific charter. Until 1844, when the UK Companies Act came for the first time, it was either through a separate act or through a specific charter of the Crown. Today, the position everywhere is that the Parliament can form a company, and the Parliament has enacted a Companies Act in which you can register. There are two simultaneous mechanisms. Something similar is happening on the university side also. Not exactly, but somewhat similar. Plus, these things keep on changing. UGC Act tomorrow can change, my lord. Your Lordship, my Lord Justice Surya pointed out, is that a problem? Today, of course, it's a problem. The way it's structured, it is a problem. But if tomorrow it says that you don't need a law for a university, Article 30 cannot be hinged on a changing regulatory landscape. That's what Basha has done by saying the minute it's an act to go out. It has to have an independent meaning, irrespective of how the law below the Constitution is changing. That's the second error that Basha makes.
Yes.
Plus, then my other submission is something which was really not a submission, but a question which arose from the bench. I'll just try to answer it in very short. Well, like Mr. Sibbal argued, and this is without prejudice to his argument, that once I have established, Basha knocks me out on establishment, then it's under the Article 30, it's my right to administer. If the Parliament intervenes through a law, I can say that's violating my right. To administer is my right the minute I'm shown to have established under Article 30.
That may not be fully correct, because even if a minority institution establishes it may not visualize the right to administer will be retained by the minority community.
Well, I agree. I just without prejudice, so I see the point.
So there is no question that the person who establishes will like to retain.
I am grateful, Malas. I'm extremely grateful. So this, Malas, takes into account.
That may not flow from the first proposition. Right or establishment itself will not lead to the conclusion that the person who is established or the community which is established is also the administrator.
So may I say it like this? There is no duty to administer, your Lordships are right, but there's a right to administer. If I want to administer it through myself, I have a right to do it. But there's no duty that I should administer it only through myself. I can do it like Mr. Sibbal argued to somebody else.
That's a different.
That's the submission.
That's a different argument.
Yes. So Malas, once I have, Malas, so there's a duty and there's no obligation that you must continue to administer through yourself.
You are in fact yourself now accepting establishment may be by one person, administration may be by another person or a community.
Because I am only saying this without prejudice to his argument, but I'm just, your Lordship will allow me to make the submission just for a moment. Because the minute there can be today, what is the legal regime? Without going into the details. Well, let us assume it's a legal regime which does not aggressively exclude others from participation in the university. That's the point. It doesn't say people who are not Muslims will be limited to 5% or 10% or 15%. Right? That's what. But can that ever be determinative? Once I have established it and I am de facto actually running it, a neutral regime does not impact my de facto administration. A legally neutral regime, the regime which can become problematic, which will infringe my right, will be this. If the Parliament tomorrow says that you, Mr. AMU, cannot have more than 20% Muslims in your EC, I'll immediately challenge it. Although I need not But I will immediately challenge it, saying, listen, I want to administrate through myself, you're violating it. But a neutral regime which doesn't reserve seats for Muslims, till that time I'm in de facto control, does not at all, I'm in administration today, the present regime does not, legal regime, does not in any way impact my day-to-day administration. I'll show that in a moment. In court, in EC, in academic council, Muslims are in overwhelming majority. With the present legal regime, why do I need to challenge it? So a neutral regime, a regime which does not, in a secular country, I am an institution of higher learning. If in a secular country run by a constitution, I have not aggressively sought to limit others, will that be a point against me? Even though factually I'm in complete control and there's no risk of losing that control. On that, Manoj, just some data. Your Lordships will have volume 3C. First, volume 3C, your Lordships will have page 551. Page 551 of volume 3C, C for Calcutta. Plus, first is MU court composition. Plus, this actually 51. This is, well, this has been filed by the university itself before your lordships. I'm just taking your lordships through it. From 19, this is the court, the actual composition of the court in terms 551. Yes, lordship. So it has taken all the different appointees, how the people in the court are appointed, different provisions on the left-hand side, and then said from year to year how many Muslims and non-Muslims were there. M and NM is the plus indicator of Muslims and non-Muslims. Plus 1983, your lordships will have at the bottom straight away. Total. I just want to show the total. Plus 165.7. This is the court. This is the supreme body as even Basha recognizes. And this is 81 onwards. 152.7, 152.11, 95.15, 137.15. Plus this ends at the latest 223 your lordships will get, 2023, at page 557. At the bottom is total. Again, 2018 is 147, 15, 129, 20, 75, 15. That is still 82%. So, at no point in time for the last 40 years, the court has had less than 80% Muslims, de facto control, despite the legal regime, whatever it may have been. Well, why do I need to change the legal regime and aggressively prevent when all my feeding bodies to the court are ensuring that the composition does not change, that the minorities are in control, in fact. And this is, well, I've showed the data for 40 years, but your lordships may take it. This is the status for 104 years, undisputed. Now, my lords, kindly have page 558, which is EC, Executive Council composition. Plus 558, the next page after. It's 558, if your lordships will have it. Next page, 558. Plus this is the EC composition from 83 onwards for the last 40 years. At the bottom, your lordships will see M16, NM4, 16.4, 15.4, 22.5, 17.4. 80 to 95% is the range. Your lordships, this ends. Just kindly have 564 for a moment. 563 first for a moment. Page 563 at the bottom. In years 2015 and 16, 21-0. 27-0, 27 Muslims know this thing. That's not something to take pride of, but the point I'm saying is that by and large, 80 to 100% EC, which is the primary executive body, is in de facto control of the minority. So court I have shown, Mullahs, executive council I have shown now. And this is with a completely secular regime, which doesn't positively say, oh, so and so has to be limited to 5%. Plus now the academic council, which is the third body. Plus court, EC, AC are the three bodies which run the university. Now the third body, which is the academic council. And that your lordships will find at page 565. Plus at the bottom, Muslims 102, non-Muslims 113. This is 83. Again, Muslims 102, 13, 91, 14. And this ends at 572, the current position. Your lordships will have the current position in 2023. 136.7 as of today. Academic council. And the reason for this is this: the way the EC, AC, etc. are the feeder mechanisms for this are in effect old boys societies, alumni societies, other minority institutions, etc. So it's ensured. So the fact that I positively, aggressively do not discriminate in my statute against others is immaterial. Because with that legal regime, I am ensured a de facto control There's no threat today with the existing regional regime of losing the de facto control. The thing which will be problematic, like I said, if the parliament says you can't in your EC have more than 20% Muslims, then I'll challenge it. But a secular regime doesn't impact me. That mixes up secularism and right under Article 30. That actually blends in very well with the scheme of the constitution as to what's the meaning of. I don't need to aggressively remove others in my document to show that, oh, I'm minority. Only if I positively exclude aggressively everybody else. So once I'm established, unless I, who have a right to then administer, feel threatened by any provision, I continue to administer the institution also. Your lordships will not just check provisions therefore and say, oh, because of this, you are excluded, therefore it's a problem.
You're not aggrieved by neither the 51 or 65 amendment.
Plus 65, really, 51 people challenged when all Muslim court was changed to a secular provision, really speaking. But Basha itself recognizes that on the ground, nothing changed because of this mechanism.
My question is not that.
Because really speaking, today I'm speaking for the petitioner. I can't, of course, speak for everybody. Speaking for the petitioner I represent, I'm not aggrieved by it. I'm not aggrieved by that. And the present dispute arises, just one detour, present dispute arises in the context of reservations. That's the next data. I'll just quickly put it and then.
That is a separate question altogether.
No, but how does, this has come to your lordships. Why this dispute arose in 2005.
If you're wanting to go into that question, then we'll have to.
No, not just, I'm just flagging something. I'm not at all going to address it on merits, not at all. Just flagging one point. The present dispute only arises not because of any provisions really in that. What happened, 50% reservation was given, and only reason to give that was in the professional schools, Jawaharlal Nehru Medical College, a very sought after college. The distribution, for instance, is almost 50-50 between Muslim and non-Muslim. Sometimes it can be 45 also, Muslims go to 45 sometimes. So there the idea was to protect that to 50. Otherwise, in the rest of the university, I have the data here, 70 to 80% student body is Muslim. The need for reservation, that's how the present dispute arises, only in the context of professional, highly competitive spaces. Medical and engineering colleges, lordships know anywhere is highly competitive. That's the space where there was basically a reservation was brought in. Otherwise, reservation is not even needed because 70 to 80% of the student body is anyways Muslim.
You have St. Stephen's College, you have DMA Pi, Xavier's in between. So don't go on that. If you go on that, we'll have to.
Well, the test in Stephens would have come to my rescue even if I was not in this position. All I'm saying, I don't even need that test necessarily, is my submission to your lordships, given my situation. Of course, if I was worse off, the test would still help me, no doubt. But just if your lordships will permit, one page if I can hand over, if lordships will permit, just the data and then of the composition of the student body.
Stop. I will drop. Then we can take.
Well, the total students today in the university is 23,675. Out of that, the Muslim students are 18,700, which comes to percentage of Muslim students 77.39%. Percentage of Muslim female students out of all the women students, 81% are Muslim. Out of the male students, 79% are Muslim. And the overall composition, 77.39. That's how it comes. So the control on the administrative side is substantial. It's catering to the Muslim community in substance. It also takes everybody else in alignment with the secular ethos of the constitution without aggressively discriminating against it. Can that be a point against me in a constitutional adjudication? That I cease to be a minority? So that's the submission on administration. That's my final submission. Well, this university has served a very important purpose of creating the educated Muslim middle class. It has literally created, I don't intend to exaggerate, it actually has education of Muslims and AMU go hand in hand. And the reason is the minority status is very relevant for that. Well, this is recognized in many judgments of your lordships as well. I'm not going to take you through them. But the point is this. Students from Bengal, from Karnataka, from Kerala, from Muslim families will send their children only to AMU. They may be today, they may not 100 years back, they may not have been great universities, but today they're exceptional universities all over the country. A Presidency College is there, Calcutta University is there, in South Manoj we have. But lot of, that's the composition, I could not place it, but the composition of AMU is from all over India. Because of its minority status, because that minority identity, which I started my submissions with, is relevant to a minority. That's why we have that Article 30. And this is especially true for women students, because the burden of bearing the cultural markers of identity, be it a majority or be it a minority, always comes on the women. And when it comes to girl education, the existence of the minority status of AMU is very relevant. It's a very important consideration in families sending their women to this institution and possibly to access higher education at all. If the institution ceases to be a Muslim minority institution, it may very well hamper the education of Muslim women in India, higher education of Muslim women in India.
Over the last 100 years, without the minority institution tag, it has continued to be an institution of national importance.
Plus, de
How does
facto,
it matter that if we are not with you on Bhasha, you started your address by saying this, that it would create great damage.
plus
Without the minority tag, institution has continued to be an institution of national importance.
So,
How does it matter
yes.
for the people whether it is a minority institution or not? It's only the brand name, AMU.
Well, may I try to answer that? Because although Bhasha came, until Bhasha it was considered as a minority institution, Bhasha came, 81 amendments sought to undo it. Thereafter, this has been litigated through. There has always been a stay, in effect, except on the reservation aspect. The 81 amendment, to the extent it sought to clarify the establishment and therefore the minority status. In my submission, wrongly so, it couldn't have done it, but that doesn't matter. There's always been a stay. So really speaking, today, because of the operation of the status quo orders of your lordships on the 81 amendment, it continues to be a minority institution. In fact, if your lordships uphold Bhasha, for the first time clearly now, it will become a non-minority institution.
The last argument may have a counterpoint. We're not going into that. There'll be a counterpoint.
That's fair enough.
That's a more.
My submission is this, that a minority.
That may not be purely a legal argument.
It may not be, because your lordships, when you are interpreting established under Article 30, your lordships will take the social circumstance in some level of account. Of course, it's not a purely legal argument. If something can promote Muslim girl education possibly and ensure the minority status, well, there's no harm in it. In a secular
women they are studying everywhere. Let's not belittle them. They are studying in every.
I'm not belittling anybody.
Not because of.
It's a fact in the community.
Yes.
It is a fact in the community. Your lordships, I mean, these are sociological aspects. So of course, your lordships will not make a judicial finding on it. But it's a fact that communities send their children generally and Muslim, women specifically because of the minority status. It's a fact. Plus, finally, so what I would submit, just I want to read out three. Plus, there is a very illustrious list of women, just want to place women alumni of AMU. Plus, that is there in, if your lordships will have my written submission, para 24, this is volume 2B. Plus, page 35, red page 35, running page 35. 1B, I'm sorry, 1B, my apologies, 1B. 1B, page 35. In para 24, in 1937, the school was upgraded to AMU Women's College. Notably, the AMU's Women's College was established at a time when the literacy rate among Indian women was just 3%, and almost 2 decades before premier women colleges such as LSR came into existence. In this manner, AMU became a catalyst for empowering Muslim women, breaking societal norms and contributing to the broader movement for women's rights and education in India during the early 20th century. The university's commitment to gender equality and educational opportunity laid a foundation for the advancement of women in various fields, contributing to their socio-economic and intellectual upliftment. The success of AMU is therefore inseparable from the triumphs of Muslim women in the subcontinent who have excelled across diverse fields. Among these are trailblazers such as Rana Safvi, a distinguished historian, Ismat Chugtai, your Lordships are aware of Lihaf, a renowned novelist, Hashima Hassan, a notable scientist at NASA, and renowned educationist Najma Akhtar. These accomplished women have made significant contribution in areas such as law, education, politics, literature, and activism, underscoring the broad spectrum of talent that AMU has fostered over the years. In fact, even the first chancellor of AMU was a woman, Sultan Jahan Begum of Bhopal. The appointment of a woman as the inaugural chancellor marked a significant historical milestone. It was the first time a woman served as the chancellor of any Indian university. So, Manoj, the point I'm making is the minority status and the women education have gone somewhat together. And it has really fostered, Manoj, education amongst Muslims, in particular Muslim women, and that can be impacted potentially. And Manoj, finally, I'll just conclude my submissions with something, Manoj, I saw in the union's written submissions by the learned solicitor. Manoj, the broad width of that submission is that you are such a great institution. You are so good, you are excellent, you have faculties across the board. How could you be minority? No, it's not. I'm paraphrasing it. I'm certainly paraphrasing it. But the point is, it is an institution of national importance. It is an institution of national importance and a big institution. It's an institution of excellence. And somewhat that leads to the fact that you are not a minority. My respectful submission is that AMU does what Article 30 requires of minority institutions exceptionally well. That should not be held against it. The fact that I'm a successful minority institution cannot be the basis for making me move out of that minority zone. So this is on the aspect. Also on entry 63, final conclusion. Entry 63, national importance, institutes of national importance. Just on that final submission. A minority institution can be an institution of national importance. There is nothing. It's not as if only the majorities can establish institutes of national importance. Well, that's my final submission. I'm extremely grateful for that.
Thank you, Mr. Thank you, Mr. Parasar.
Only one question. Is there any other institution, minority institution in the country, which is 100% funded by Government of India?
I cannot perfectly answer that because I don't have the data, but my understanding is that most minority institutions, including Jamia Millia Islamia, for instance,
100%.
100%, substantially, nearly 100 it would be, exact numbers I can't, but substantially funded. Even Jamia Millia Islamia in Delhi, which is established under the 87 Act of Parliament, will almost be nearly 100. I can't vouch, of course, if it's exactly 100. I'm grateful.
Your Lordship, whatever time I am left with, Your Lordship may permit me on two aspects. One is how Anjuman Rahmania approached Your Lordship in 1981 and how finally that petition was disposed of. Despite on 26 November 1981, Honorable 2 judges referring the matter to 7 judges. So first, Your Lordship may have the reference. I need to read few lines of that reference because it is important. Your Lordship may have 3A 209, volume 3A 209. I have placed that writ petition also on record, my lord, of 1981. The circumstance due to which that petition came to be filed. 3A 209, if Your Lordship has, at the bottom, Your Lordship has recorded
about 15 minutes or so.
If Your Lordship gives me 15 minutes today, I'll be able to conclude. Otherwise, Your Lordship may give me next day.
So Shamsad, we don't want to rush you. You take your 10 minutes or 15 minutes after we come back. Next week we are not sitting.
I'm so deeply obliged.
Hmm?
I'm
Then
so
we give
deeply
you-
obliged.
Then now, we'll be sitting on the 23rd for this matter. We'll give you 15 minutes, but keep down.
I'll not exceed 20 minutes, my lord. 15 to 20
15.
now. I'm so deeply obliged.
Doesn't have its time. Rushed by the fact that you are rising, so we'll give you a little time on.
I'm
the
so
go.
deeply obliged.